This is Judge Hatcher, just an announcement for all those on WebEx or listening to the live stream. We have not begun yet. We will be beginning in just 1 or 2 minutes. And the first issue will be issue number 30, the WNAR and RNA. Again, we'll begin in just a couple minutes. Let's go on the record. Good morning, everyone. Today is August 4th. The Commission has continued to set this time aside for an evidentiary hearing in file number GR-2021-0108. We begin today, Wednesday, with many opening statements on the issue of number 30. That's WNAR and RNA. We'll begin opening statements with Spire. If you'd like to come on up.
Good morning. Is my mic on?
It should be.
Okay. Good morning, Judge. May it please the Commission. My name is Ann Kallenbach, and I am outside counsel representing Spire in this proceeding. In this case, Spire proposed a rate normalization adjustment rider to replace its weather normalization adjustment rider. Spire's proposed RNA was prepared and submitted in accordance with Section 386.366 subsection 3 of the Missouri Revised Statutes, which permits a utility to file a tariff to account for the impact on utility revenues of increases or decreases in residential and commercial customer usage due to variations in either weather, conservation, or both. As you will hear from Spire witnesses Scott Whitesell and Tim Lyons, Spire's proposed RNA is designed as a 2-block rate mechanism, where Block 1 represents monthly customer usage and revenues up to a set threshold, and Block 2 represents the remaining monthly customer usage and revenues. The RNA is designed to expose Spire to the benefits or risks or variations between actual and normal usage and revenues, and insulate Spire to an extent and its customers in Block 2 to the benefits or risks of variations between actual and normal usage and revenues. The RNA has 2 primary benefits. First, to limit the degree to which customers collectively under or over contribute to Spire's revenue requirements, and second, to pass customers the benefits or detriments or increases or decreases in usage associated with customer growth. Staff filed a similar RNA mechanism in this case. The primary difference between Spire and staff is where to set the breakpoint of the block rates between blocks 1 and 2 for the residential class, and similarly, where to set the threshold breakpoint for the small general service class. For residential customers, Spire is proposing a breakpoint at 30 CCS, and staff is proposing a breakpoint at 50 CCS. For the SGS class, Spire proposes a breakpoint of 100 CCS as compared to the range of 300 to 500 CCS proposed by staff. OCC will set forth several arguments in an attempt to resurrect and revise the WNAR, but staff and Spire agree the RNA rider is a better approach. Spire maintains that the RNA it proposes is the appropriate rider to implement and will demonstrate that its proposed block rates, and not those proposed by staff, minimize the Block 1 sales that would be subject to fluctuations due to weather and conservation by the residential and SGS classes as contemplated by Missouri law. Thank you. I have nothing further. Unless there are questions.
No? Thank you, counsel.
Thank you.
We'll move on to staff. Mr. Stokes, come on up.
May it please the Commission. Kurt Stokes for the staff of the commission. Good morning, Chairman Sylvie, Commissioner Coltmeyer, Judge Hatcher. Staff is asking the commission this morning to approve staff's version of the Rate Normalization Adjustment Mechanism, or RNA. Section 386.266.3 of the Revised Statutes of Missouri Section 386.266.3 of the Revised Statutes of Missouri authorizes the commission to approve for the residential class and the small general service class, quote, rate schedules authorizing periodic rate adjustments outside of general rate proceedings to adjust rates of customers. The statute continues, quote, to account for the impact on utility revenues of increases or decreases in residential and commercial customer usage due to variations in weather, in either weather, conservation, or both. Under staff's proposed RNA, residential usage is separated into two blocks, blocks 1 and 2. Small general service, or SGS customer usage, is separated into 3 blocks, what staff refers to as 1A, 1B, and 2. The company would retain the risk on the first block of volumetric recovery for residential customers, and for block 1A and block 2 for SGS customers. The RNA insulates the company from fluctuations in sales due to weather and conservation compared to what is normal for residential block 2 and SGS block 1B. Under staff's proposal, block 1 would be 0 to 50 CCF for residential customers, and block 1B would be 300 to 599 CCF for SGS customers. Under staff's RNA, the company retains the opportunity to increase its returns by increasing the number of customers taking service, but the company retains the risk derived from customers leaving the system. Staff's proposal therefore most closely reflects the intent and purpose of the statute, which is limited to usage fluctuations due to weather and conservation. Spire's definition of conservation is too broad and includes, quote, energy efficiency measures, comma, as well as any other factors inducing changes to the volumes of gas sold. Spire's proposed blocks of 30 CCF and 100 CCF are too low. Spire's proposal creates the risk of insulating the company from more than just weather and conservation. There is an alternative request in this case for continuing with Spire's currently existing weather normalization adjustment rider, or WNAR. Staff requests, if the WNAR is continued in this case, the tariff be filed with a 60-day effective date rather than 30. The purpose of this request is to give staff time to perform the review and work with the company on any corrections to the tariff filing. And the reason we're asking this is that currently the 30 days give staff approximately 10 to 15 days to make those corrections, and that has not proven sufficient. And every WNAR filing to date has required some back and forth between company and staff to get clarifications or corrections. If there are no further questions, that's all I have.
Thank you, Mr. Stokes.
Thank you.
And for Office of the Public Counsel, Mr. Kleiser.
Please the commission. I'm going to check my get picked up. Super. Please the commission. Good morning. You heard Spire say that the OPC is going to argue that we want to resurrect or revive the WNAR. Let me start off by saying that's not actually what we're asking. The first thing I want to point out here is that the statutes that you've been heard quoted from do not require the commission to approve anything. There is no obligation that Spire have a WNAR, an RNA, or any mechanism. And we believe that Spire has failed to demonstrate why it should have any mechanism at all at this point. In fact, over the last year, Spire has demonstrated that apparently it doesn't actually need the revenue from the WNAR, as it failed to update its WNAR to account for changes and collect revenues it was supposed to be collecting. But if the commission does choose to grant Spire a mechanism, it should use the existing WNAR, which has been in place for a while now. There's nothing wrong with it. It works perfectly. There are a few modifications that have been recommended by both staff and OPC, and I think we agree with all the recommendations that both staff and As far as the RNA goes, I'm going to keep it simple. This is decoupling by another name. The commission previously determined it doesn't have the statutory authority to grant such a mechanism, and we would ask the commission to make that same determination again. Are there any questions?
Just one, can you provide me the citation for that decision?
It is the last rate case.
Oh, the GR-17?
2017-0215
Okay.
and I believe 0216.
Thank you. No other questions? Thank you, Mr. Kleiser. Let's move on to our first witness, Mr. Weitzel. And I believe you have already been sworn in, sir? No. Okay. Please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. Please have a seat. Would you please state and spell your name for the court reporter?
Scott Weitzel, W-E-I-T-Z-E-L.
And Spire, your witness.
Thank you, Judge. Good morning, Mr. Weitzel.
Good morning.
Would you please provide your business address for the record?
700 Market Street, St. Louis, Missouri.
And by whom are you employed and what is your title?
Spire, Missouri, Managing Director of Regulatory and Legislative Affairs.
Are you the same Scott Weitzel who filed direct, supplemental direct, class cost of service rebuttal, revenue requirement rebuttal, and surrebuttal testimony in this proceeding on December 11th, 2020, March 12th, 2021, June 17th, 2021, and July 14th, 2021, respectively?
Yes.
And did you also adopt the direct testimony of Wes Sellinger filed on December 11th, 2020?
That is correct.
Do you have any additions or corrections to make to any of your testimony at this time?
Not at this moment.
If I asked you the same questions today, would your answers remain the same?
They would.
Thank you. Your Honor, I move to the admission of all of Mr. Weitzel's testimony into the record as exhibits 39, 40, 41, 42, and 43, and exhibit number 34, which is Mr. Sellinger's direct testimony that has been adopted by Mr. Weitzel. And with that, I tender the witness for prompt.
Okay, we will cover the exhibits first. Do we have any objections to admitting exhibit 39, 40, 41, 42, and 43, all the various testimonies of Mr. Weitzel, and exhibit 34, which is the direct testimony of Mr. Sellinger, which is adopted by Mr. Weitzel? Are there any objections? Hearing no objections, it is so admitted. The witness has been tendered. Mr. Stokes, your witness.
Staff has no cross-examination.
Thank you, sir. And Mr. Kleiser?
Good morning, Mr. Weitzel.
Good morning, sir.
I'd just like to briefly kind of walk through exactly how the RNA works. So as I understand it, the RNA is going to set an assumed usage for a given block, correct? And obviously what block that is sort of up to debate, but that's effectively how it works, right?
Correct.
And then if the actual usage is more than the assumed usage that's set in the rate case, the RNA rates will be increased and customers will get lower bills, right?
If there's a colder winter and that usage and revenue produces more than the billing determinant set in this case, yes.
And the same is true in reverse. If the actual usage is less than what's set in this case, the rates will be higher and customers will have a higher bill, right?
Yes.
So the RNA is based on usage, effectively, in that block.
The RNA is based on usage to a point, and then once you get to that second tier block, it then reverts to a revenue reset.
Yes, okay, but within the block, it's based on usage.
Yes.
And so obviously,
block.
a change in usage will change the RNA, correct?
A change in usage will impact the first block, but not necessarily the second block, which that's what the RNA rate is derived from.
if someone changes the amount of usage in the second block, it will affect the RNA.
Correct.
Right. So if a customer who is in that second block leaves because, for example, they stop taking gas service, that will change the RNA, correct?
Correct.
And if a customer who's in that second block leaves because they switch to a different class that's not subject to the RNA, that will affect the RNA, correct?
For the SGS customers, more than likely, that's a possibility.
If a customer is in that block and they leave because they change class, that will affect the RNA.
Sure.
Okay, sure, that's a yes.
Yes, Mr. Clausen.
All right, thank you. Let's say that we have another lockdown, for example, and we have a bunch of people at home during the winter. Is that going to affect, if you have a bunch of people at home and they're in that second block and you have more usage, is that going to affect the RNA?
Yes.
And then like if we end the lockdown, people come back out and we have less usage in that second block, that's going to affect the RNA.
Yes.
And if we go into a recession and people literally can't afford gas and you have less usage in that second block, that's going to affect the RNA.
Yes.
All right, last question for now. Does Spire have a problem with people switching classes?
I don't think we have a problem switching classes. You know, most of our classes are based on usage, and if a customer falls within a new usage class, then that's their right for the tariff provision.
Okay, fair enough. Let me change the word problem. Does Spire see a lot of class switching?
Per our tariffs, every year we have to go in and reclass SGS and LGS customers. So amongst those, there are class switching, but residential to other classes is rare.
Fair enough. I have no further comments. Thank you. Thank you, Mr. Kleiser. That leads us to bench questions. I do want to state for the record, here in person, again, we are having a hybrid hearing, so we have some participants on WebEx and some participants here in the courtroom. For the record, I'd like to state that we are joined in person by the chairman, Chairman Ryan Silvey, and also Commissioner Glenn Kolkmeyer. And also a reminder for those on WebEx to unmute yourself from the phone. It is *6. We are at the testimony of Mr. Weitzel on the issue of WNAR/RNA. Are there any questions from the commissioners? Hearing none, the bench also has no questions. Mr. Weitzel, I believe that leaves you dismissed. Thank you, sir.
Thank you, Judge.
Mr. Michael Stallman. Mr. Stallman, please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you, sir. Please have a seat and state and spell your name for the court reporter.
Michael Stallman, S-T-A-H-L-M-A-N.
Your Honor,
Yes.
I believe there was a second Spire witness for this issue.
I don't have one, but we will. Mr. Stallman, would you please excuse me for calling you up? I apologize. However, you are already sworn in.
Thank you.
So there was an advantage. Let me go get on the computer and I will bring up the witness. We have the witness computer set up here in the courtroom because our witness, this will be our first WebEx witness. So those listening on the live stream, that is what will be happening for the next few minutes And those on WebEx, you'll be able to see those in the courtroom. Give me a few minutes, and you will also be able to see the witness. Hey, Kayla, would you make hearing room audio, would you unpin that from the stage? But I need Mr. Lyons to continue to be pinned to the stage so that we can see him here. Thank you. Mr. Lyons, welcome. Can you hear me?
Yes, I can. Good morning, Judge.
Would you please raise your right hand, sir? Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you, sir. Would you please state and spell your last name for the court reporter?
It's Tim Lyons, Lyons.
Thank you, and fire your witness.
Thank you, Judge. Good morning, Mr. Lyons. Can you hear me all right?
Good morning. Yes, thank you.
Great, thank you. Would you please state your business address to the record?
Yes, it's 1900 West Park Drive in Westboro, Massachusetts, 01581.
And by whom are you employed and in what capacity?
Scott Madden, and I'm a partner.
Are you the same Tim Lyons who filed direct testimony, rebuttal testimony, both class cost of service and revenue requirement, and rebuttal testimony in this proceeding on December 11th, 2020, June 17th, 2021, and July 14th, 2021, respectively?
Yes, I am.
And do you have any additions or corrections to make to your testimony at this time?
No, I don't.
Thank you. If I asked you the same questions again today, would your answers remain the same?
Yes, they would.
Thank you. Judge, I move to enter all of Mr. Lyons' testimony into the record as exhibits 25, 26, 27, and 28.
You've heard the list read by counsel. Does anyone have any objections to the admission of said testimony? Hearing no objections, it is so admitted.
And we would tender the witness for cross-examination.
I believe that goes to staff.
Kirk Stokes for staff. Mr. Lyons, is the RNA designed to be a decoupling mechanism?
No.
And is the RNA designed similar to a mechanism approved by the Commission for Ameren, Missouri gas?
Yes. My understanding of the Ameren mechanism is yes, it's very similar to the RNA.
I have no further questions.
Thank you, and Mr. Kleiser.
With regard to the Ameren mechanism, well, sorry, let me start by saying good morning, Mr. Lyons.
Good morning.
With regard to the Ameren mechanism that you just described, that was approved in a case in which the mechanism was part of a stipulation, correct?
I'll accept that.
So that would be a yes.
Yes, I believe so. It's been a while since I've looked at that, but I believe it was part of a settlement.
That's my question. Thank you.
Thank you, Mr. Kleiser. That brings us to any commissioner questions. Hearing none, the judge has no questions, and I believe that takes us to redirect.
Yes, thank you, Judge. Mr. Lyons, you were just asked by staff if the RNA is a decoupling mechanism. Would you please explain why it is not a revenue decoupling mechanism?
Sure. Typically, a revenue decoupling mechanism is a full reconciliation mechanism, whereas the RNA is a partial reconciliation mechanism. So, for example, with revenue decoupling, that reconciliation of revenues between what the company actually receives versus what's authorized in a rate case is really done in two ways. It's either there's a comparison of the absolute revenues. So, for example, if the authorized revenues were 100 million, there's a comparison between the actual revenues versus that 100 million target. Or a second way that it's done is on a revenue per customer basis. So, for example, there might be a authorized revenue of $500 per customer, and then the actual revenue per customer is compared to that. But in both cases, it's a full reconciliation mechanism of all revenues, whether it's done on a total revenue or it's done on a revenue per customer basis. Under the RNA, it's a little bit different because the reconciliation, that difference between actual revenues and authorized revenues, is only done for the second block. So there's a certain amount of usage where that reconciliation is not done, and then the remainder is done in that second block. So it's not a full or complete reconciling of revenues between actuals and authorized.
Great, thank you.
Thank you, Mr. Lyons. You are dismissed from the virtual witness stand. Please feel free to stay on the WebEx and listen as we go along.
Thank you very much.
Mr. Stallman, if you would be so kind as to come back to the witness stand. Mr. Stallman has already been sworn in, so we will give him over to Mr. Mr. Stokes.
Good morning, Mr. Stallman.
Good morning.
Can you spell your name again for the record one more time?
Michael L. Stallman, S-T-A-H-L-M-A-N,
Thank you. And how are you employed?
with the Missouri Public Service Commission as a regulatory economist.
Have you prepared in this proceeding direct testimony pre-filed in EPIS and marked as Exhibit 103?
Yes.
And have you prepared in this proceeding rebuttal testimony pre-filed in EPIS and marked as Exhibit 123, and rebuttal testimony pre-filed in EPIS and marked as Exhibit 138?
Yes.
Did you contribute to the staff cost of service report marked as Exhibit 101?
Yes.
And did you contribute to the staff class cost of service report marked as Exhibit 104 and the corrected staff class cost of service marked as Exhibit 105?
Yes.
And do you have any corrections to make to your contributions to the cost of service report, class cost of service report, corrected class cost of service report, direct rebuttal or rebuttal testimony?
No.
And if I were to ask you the questions in those documents, would your answers be the same as directed?
Yes.
Okay. And are those answers true and correct to the best of your knowledge and belief?
Yes.
No further questions. I apologize. I would like to move Exhibit 103, 123, and 138 into evidence.
You've heard the list of exhibits, which are Michael Stallman's various testimonies, Exhibit 103, Exhibit 123, and Exhibit 138. Are there any objections to the admission of that testimony onto the record? No objections, it's so admitted.
No further questions.
And the witness has been tendered. That goes, I believe, just fine. Thank you.
Good morning, Mr. Stallman. How are you today?
Good, thank you.
Good. I just handed you, what has been previously marked as Fire Exhibit 48. And I'll just wait a minute to make sure that copies are distributed. Mr. Stallman, have you seen this document before?
Yes,
And, is this the Ameren UE Delivery Charge Adjustment Rider or the DCA?
yes,
And if I could get you, if you turn to page 2, under rate case information, would you please just read that first sentence into the record?
from GR-2021-0077, the normalized annual natural gas usage in Block 2 greater than 30 CCF for residential customers is 44385,230 CCF, and Block 1D between 101 and 400 CCF for general service customers is 10215,167 CCF.
Thank you. So, so this has the block break for this tariff at 30 CCF, is that correct?
Yes,
And is this tariff similar to the RNA that has been proposed in this case by both Spire and staff?
it is similar, yes.
Right, thank you. We have no further questions, but I would move to the admission of Spire Exhibit 48.
Spire Exhibit 48 has been asked to be admitted as evidence on the hearing record. This is a tariff sheet from Union Electric Company Gas Service, the Delivery Charge Adjustment Rider, the DCA rider. Are there any objections to the admission of Spire's Exhibit 48 on the hearing record?
Is this the currently effective tariff sheet?
Is this currently effective, was the question?
Yes, it is. I believe it's on their website currently.
Yes, if that's the case, if it's currently effective, then no objection.
No objection, sir. It is so admitted onto the record.
I apologize. Could you repeat that, Judge?
Your exhibit was admitted onto the record.
Thank you.
Do you have any further questions?
We just have one additional question. Mr. Stallman, do gas utilities have, is there a Missouri Energy Efficiency Investment Act in place?
For natural gas utilities,
Yes.
there's currently not a natural gas energy efficiency investment act authorized by statute.
But there is one in place for electric utilities, correct?
Correct.
Thank you. And, I'm sorry, I have one more. So the RNA is designed to extend the conservation protections that would be similar to the Act to natural gas utilities.
Objection calls for legal conclusion.
I'll withdraw. Thank you. Nothing further.
Mr. Kleiser, your witness.
Good morning, Mr. Stallman.
Good morning.
I'm going to ask you a series of questions regarding the proposed RNA. Now, I know that there is a disagreement among the parties as to what the appropriate block break should be. I'm just going to to the block, and I mean whatever block is approved by the commission, assuming the RNA is put into place. Do you follow me?
So when you refer to block, you're basically going to be referring to block 2 for residential and block 1B of the small general.
Correct. I want to make sure that I'm not sticking to a specific number because that's still in flux.
Okay.
So for residential usage within the block, would the RNA make adjustments for fuel switching?
It could.
Would it normalize for fuel switching?
I don't know.
Would it differentiate between fuel switching and weather or conservation?
Can you explain the question, please?
If a customer left the block because they made a decision to switch from gas to electric or otherwise stop taking gas services, would that affect the RNA?
It could.
Or that block, would the RNA make adjustments for rate class switching?
I know there was discussion with Ms. Mantle. She had proposed some for the SGS customers, a way to correct for the customers leaving.
Without that correction, though, it would have, the RNA would be affected by rate class switching, correct?
It could, it depends. That's one of the important things on having the cap for the SGS class as proposed by staff.
I'm talking about just the residential class. I'm sorry, I did not make that clear. For just the residential class, the customer leaves that block. What staff proposes to be above 50 CCF block.
I would be unaware of how a residential customer would switch to a different class.
Okay, fair enough. For residential customers in that block, which again, staff proposed above 50 CCF block, would the RNA make adjustments for economic factors?
It depends on what you would find as economic factors. I would see a lot of economic factors actually impact under the definition of what staff use for conservation.
You were asked questions about the Union Electric Company delivery charge adjustment rider, effectively the tariff provision was entered into evidence. You recall?
Yes.
You were part of the Ameren gas case where that was put into place.
Yes.
Did you propose a volume indifference reconciliation to normal rider in that case?
I'm trying to remember if it was specifically my testimony or if it was staff, but I think the answer is yes.
And did the parties to that case stipulate or enter a stipulation that agreed to adopt that mechanism with adjustments?
I don't recall.
Your Honor, I'd like to mark an exhibit, which I believe would be
232 is my number.
as is mine. Thank you.
So marked.
Unfortunately, we had to do this in a rush job, and I only have the one copy, which I'm going to hand to the witness. And I will explain that this is something in EFIS, and if you would like, do apologize.
Someone in your, Mr. Kleiser, someone in your office is listening, I assume.
I kind of hope so.
Would you request the person that you think would be best suited to go ahead and, in the background, get those copies made and run down to the courtroom while we continue with the questioning of Mr. Stallman?
Certainly, and I will, as soon as I'm done here, text somebody in my office to make absolutely certain. So I need 12 copies of attachment A to the order approving stipulations and agreements and compliance tariffs for case GR-2019-0077.
Go ahead.
Mr. Stallman, can you find the section regarding the VRIN?
I have the, paragraph 15 of titled Modified VRIN on page 6.
And I'm going to paraphrase here to make this quickly as possible. You would agree that that paragraph is referencing what ultimately became the delivery charge adjustment rider referenced in this tariff?
Yes.
I know. Can you turn to the first paragraph under the header, General Provisions of Agreement? I believe it's paragraph 28.
I have a paragraph 27 under.
Now, normally I'd like to read them out loud because I don't want the witnesses to have to read, but unfortunately in this circumstance, can you just read that paragraph out loud?
Paragraph 27.
Correct.
Okay. On page 9, this agreement is being entered into solely for the purpose of settling the issues in this case explicitly set forth above between the signatories. Unless otherwise explicitly provided herein, none of the signatories to this agreement shall be deemed to have approved or acquiescence in any rate-making or procedural principle, including without limitation any cost of service methodology or determination, depreciation principle or method of cost determination or cost allocation, or revenue-related methodology, except as explicitly provided herein. None of the signatories shall be prejudiced or bound in any manner by the terms of this agreement in this or any other proceeding, regardless of whether this agreement is approved.
Thank you. I would like to offer OPC Exhibit 232, which again is Attachment B, Attachment A, to the order approving non-unanimous stipulation agreement filed in case GR-2019-0077.
Are there any objections to the admission of Exhibit 232? No objections, so admitted.
I have no further problems. Thank you.
Thank you, Mr. Kleiser. I would like to just make a quick announcement again for those listening on our live stream and those on the WebEx. We will be taking a recess at 10 o'clock. I have my alarm at the bench set, so when we hear the old car foghorn, then we will be taking a break at that time. The commissioners need to get to their agenda. This will provide them time to get back to their office, trade this paperwork for that paperwork, and then we'll come back after agenda. Mr. Kleiser has just finished his cross-examination of staff's witness Stallman on issue 30. This now leads to commissioner questions. If there are any commissioner questions for Mr. Stallman, hearing none, we'll go to other questions. The judge does have some questions. Mr. Stallman? In your rebuttal testimony, you indicated that staff has some issues with Spire's WNAR filings. What have those issues been?
There has been, getting some of the source data to justify the numbers that they used, and, there's been issues just on reconciliating the prior rates with the current rates. And occasionally there will just be like a miscalculation, if I recall correctly. And I should also mention there was a large case where how weather was ranked was in dispute at the initial onset of the WNAR.
I think that's more what I'm trying to get at. What, could you describe to me what staff's issues are with the WNAR?
I would agree that the WNAR does work as a mechanism. There's just I think there's difficulty understanding how the WNAR works in the context of the difference between a calendar month and a billing cycle month. So you will see changes in like the February weather ended up being really cold, but that was more in the middle to end of that calendar month. So if you're filing for a new rate and you don't include that, or if it only goes through January, or even part of the February bill cycle, it may not see that just because of the way the billing cycles overlap differently from what the actual calendar month. And so I think it was in rebuttal testimony, I noted on page 3 that the first billing cycle, and this is February of 2020, only had 6.3% of the calendar date in February. So that's generally a January weather month, but not understanding that differences creates a lot of confusion on, it was really cold, why are we not seeing this rate reflected in the rates that are being proposed?
Were there any other issues?
I can't recall any other issues. It was just basically not understanding how the ranking works and in the context of billing cycle versus a calendar month.
Staff recommended an RNA. How is that going to address the issues that staff had with the WNAR?
In large part, there's going to be, this is information that the company's going to have. They're going to, they seem to understand it a lot better than they do the ranking of the weather and how that impacts things. I should also mention, they're not with Spire's WNAR, but with another company, there was a problem of the weather station just no longer recording the actual temperature differences. And that, trying to find a substitute for that took several months of doing some research. And so I think the company just inherently understands revenues a lot better than they do ranked weather. So that I would expect the filings to be a much more smoother, that the data will be presented a lot better than what they have for the WNAR.
Okay, so the switch not only, staff's recommended switch not only addresses procedural background issues, but it would also address the more substantive issues of how the actual mechanism works.
I think so, yes.
Okay, I'm making that distinction because when I first asked you about issues, you had described their filings had focused on maybe some errors or miscalculations in those filings, and I would consider those more procedural types of issues. And so your fix is addressing both those and the underlying mechanism itself.
Yes.
Okay, thank you, I appreciate that. I'm gonna ask you about Ms. Mantle's surrebuttal testimony. Do you have that in front of you?
I do not have a copy of her rebuttal.
I see a copy is getting ready to be brought over to you. We'll wait for a second.
I do have a copy.
Excellent. I'm gonna ask you to turn to page 10, and I'm gonna focus on lines 3 to 5. And while everyone is turning to that, I do notice that the technology gods have come to visit our hearing again inside the courtroom. Right over the judge, we have light bulb flickering. So I'm just announcing that for everyone on the live stream so they can also participate in our technology challenges, or follow along at least.
Judge, what was the page and line numbers?
Page 10, lines 3 through 5. So rebuttal. Okay, Ms. Mantle raised the concern that the staff's proposed RNA not only addresses the impact of weather and conservation, but, quote, everything else that impacts revenue, end quote. Does staff's RNA have the possibility to respond to not only weather and conservation, but other factors?
There's going to be a legal argument on what the other factors may be. Under staff's definition of conservation, it was provided from Lester's third New International Dictionary that the wise utilization of a natural product, especially by manufacturers, so as to prevent waste and ensure future use of resources that have been depleted. That is a fairly broad definition. So there's a lot of economic factors that are going to be included in there. There are some factors that are largely not going to be included, such as if a customer leaves the system. That's primarily going to be more at the first block issue. That's where Spire retains risk. But as far as some factors under that definition of conservation, so with, as an example, the Corona outbreak, you had, in this case, people were spending more time at home rather than at work. And so what you see is that the industrials, and it would include small general services, that rate would have, or the usage would have gone down, and the residential would have gone up. So the RNA would impact that because it's under, that would still be a conservation thing. Nobody's going to the store, so I'm going to turn down the heater or whatever. That's the choice that the people make, where at home, I'm spending more time here, so I'm not going to lower the thermostat as much as I did in the daytime, and instead raise it. That I would consider under the conservation definition.
Would it also capture other issues, rate switching between, I guess, the SGS class, or also consumer decisions not to use gas? Would either of those also be caught up in one of the adjustment factors?
Rate switching, this is, with the residential, I don't see rate switching being an issue. With SGS, there was a modification proposed by staff OPC witness Lena Mantle that I think staff was very open to on correcting for any rate switching from SGS to LGS or vice versa. And that was also a large point of why we wanted that cap Block 1B. And the other half of your question was to the fuel switching?
Yes, a consumer decision either not to take natural gas at their new home construction or some consumer switch to another energy product.
And part of that could be still seen under the broader conservation definition, that they're making a decision to choose which form of fuel, best suits them. So is that the wisely use and not waste? If they think that having a natural gas furnace is more efficient than a electric furnace, then they can make that decision, and that would broadly be under a conservation. It's kind of under that economic calculation.
Okay. And you actually brought up my last question. Ms. Mantle, in her testimony, her rebuttal, had recommended several changes to staff's proposed RNA tariff. And I'm referring to Ms. Mantle's schedule MM-S-2. Does staff agree with those proposed changes?
I don't think we had any opposition to the changes. There was a question on, such as the billing of blocks, whether Spire's billing system could do it. And so we largely remained neutral on whether that would be something they can do or can't do. And yeah.
Okay, thank you, Mr. Stallman. That inquiry now takes us back to re-cross-examination. For staff's witness, I believe we start with Mr. Kleiser. For cross? No, we started with Spire for cross.
No questions.
Thank you. Mr. Kleiser, on recross?
You were asked about a series by the bench questions about your issues with the WNAR. Do you recall?
Yes.
Were the issues you addressed issues with the WNAR mechanism itself, or with Spire's understanding of the WNAR mechanism and how it works?
I think it was with Spire's understanding and implementation of the mechanism.
You were asked a question, or rather, actually, I think in response to a question, you mentioned issues regarding weather data. Do you recall that?
Yes.
The weather data issues that you addressed relating to other utilities, from whom did they receive weather data?
Both the utilities provide them the weather data, and the weather data comes from the Midwest Regional Climate Center, which is I'm not sure subsidiary is the right word, but they're under the NOAA, National Oceanographic and Atmospheric Administration. I can't remember the acronym right offhand.
Where are the stations that you receive data located from? Do you know?
There's,
For Spire?
for Spire, it is St. Louis at Lambert Airfield and Kansas City International Airport.
Is that the same location for the other utility you mentioned that you have the data problems with?
No.
Do you think that KCI International or Lambert is going to stop reporting weather data anytime soon?
Objection calls for speculation.
Withdrawn. No further recross. Thank you.
I will just ask if there is any redirect. I don't want any questions because it's 9:59. Staff's witness, I'm sorry, Mr. Stokes.
Yeah, we will have some redirect, but I think we have 1 minute until then, so,
Will your question and answer take longer than 1 minute?
I think we would, yes.
Okay, let's go on a recess. I'm a little hesitant how I want to structure the time. Across the street, we used to say upon adjournment of the agenda meeting, we will meet back here. That seems to require that everyone in this room also pay attention to the agenda, which may not be applicable. Let's call it 10:45 or 11.
30 minutes.
Let's call it 10:45 to get up and down the stairs. We are on recess until 10:45. Thank you all. We're off the record. Thank you, sir. Appreciate that.
2:32.
Oh, we did, for coming up?
2:32.
Okay.
No, we can't pick up on this issue.
Thank you all. The hour of recess having expired, let's go back on the record. Just to recap for those on WebEx and listening to the live stream, we are in the middle of the testimony of Michael Stallman of PSC staff on the issue of WNARs and RNAs. This is issue number 30. Mr. Stallman, you have already been sworn. I just want to inform you that it's still in effect. We have already gone through direct, cross, bench questions, recross, and we are now at redirect. Mr. Stokes, go ahead.
Thank you. Kurt Stokes for staff. Mr. Stallman, do you remember on cross earlier, you were asked about Ameren's DCA rider? Are you still familiar with the Ameren DCA rider?
Yes.
And were you involved in the design of Ameren's DCA rider?
Yes.
And from your understanding, was that rider based on, were the blocks in that rider based on an analysis of Ameren usage?
Yes, I believe that's correct.
Okay. And you were also involved in staff development of the RNA, staff proposed RNA in this case, correct?
Correct.
And did you base your design of the RNA on Spire usage?
To be clear, this Sarah Lange designed the blocks for the RNA, but it was based off usage.
Okay. And you were also asked about the ways that economic factors might encourage conservation efforts. Can you provide some examples that might help clarify or illustrate what you meant by that?
Where economic factors can impact conservation? Sure. So if something broadly happens, like the natural gas price goes up just on the, would reflect in the customer's bill, that could provide incentive for them to invest in energy efficiency devices. And that the reason why the price could go up for natural gas could be any number of reasons, including just legislation on restricting pipeline throughout the nation, or other issues dealing with green energy promotion and other fiscal policies.
Okay. And is natural gas a finite resource?
Generally, yes.
And it's possible to deplete stores of natural gas?
Yes.
So if somebody uses less natural gas, would you consider that conservation?
Largely, yes.
And earlier, from the bench, you were asked, or you mentioned some issues with the WNAR source data. Do you recall that?
Yes.
And when you say source data, one of that was weather data, correct?
Yes.
And you had mentioned some issues with another utility's weather data. Can you tell me who that utility was?
It was Liberty Utilities, and they had used a weather station in Kirksville, Missouri, that for unknown reason, I tried contacting the weather agencies responsible, and there was no indication of why it went down or how long it was going to be down. I checked the station just yesterday, and it's still, there's spontaneous recording of the temperature. So it's mostly missing data, but there is occasionally an entry for a day's temperature.
But for a long time, that Kirksville weather station was in fact not reporting the data needed to calculate.
I would still say it's still not recording the data needed.
And did staff in fact anticipate that weather station would go down before it went down?
No.
Do you anticipate that the RNA would have similar issues with source data?
No.
You were also asked earlier about other factors that might impact the RNA other than weather and conservation. Do you recall that?
Yes.
Is it possible to design a mechanism that completely avoids being affected by other incidental factors?
I do not think so.
Okay. You were also asked a question earlier about, there was an example about new construction and what effect that might have on the RNA. Do you recall that?
Not exactly.
Okay. So, hypothetically, would new construction be reflected in the current cases billing determinants?
That exists now or exists after this?
That will exist as ordered in this case.
Okay, so that would not be reflected in the current billing determinants.
Okay. And would the current billing determinants be one of the elements of the RNA?
Yes.
And earlier you had mentioned not knowing about certain changes in usage, but can you tell me what offsetting means?
I'm trying to recall the context in which I said it. But generally offsetting means as one factor goes up, there may be another indication, like another factor goes down, so it counteracts each other.
Can you give like an example of that?
Let me try and think of a good example. Unfortunately, I'm going back to the nuclear reactor analysis, and so an example in that case would be with reactor power on most reactors, at least all United States reactors. As the power goes up, that causes the temperature of the reactor to go up, which that moderates less neutrons, which drives the reactor power to go back down. That's called positive alpha T, or temperature coefficient of reactivity.
In the weather and conservation context, if one customer were to leave the system and another customer comes onto the system, would that be an offsetting effect?
Yes.
And earlier you were also asked about possibility of fuel switching, for example, from natural gas to electric. Do you recall that?
Yes.
Would the customer charges in the first block of staff's proposal be protected, or would the company be protected from fuel switching for customers in that first block?
No.
And the currently effective WNAR, there's a coefficient for weather, right?
Yes.
And so would the currently effective WNAR be completely insulated from customer growth or customer attrition?
No, it would not. That would have an impact on the coefficient potentially.
No further questions.
Thank you, and Mr. Stallman, you are excused from the witness stand. That brings us to Ms. Mantle. If you would please approach the witness stand. Please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
Thank you. Please be seated. Would you please state and spell your name for the court reporter?
My name is Lena Mantle, L-E-N-A, my first name, and Mantle is M-A-N-T-L-E.
Thank you. And Mr. Kleiser, your witness.
Good morning, Ms. Mantle. Can you please tell us by whom you are employed and in what capacity?
I'm employed by the Office of the Public Counsel as a senior analyst.
And did you prepare or cause to be prepared direct, rebuttal, and surrebuttal testimony for this case?
Yes.
Do you have any changes to make to that direct rebuttal or rebuttal testimony?
No, I do not.
I've asked you the same questions that were posed to you in the direct rebuttal or rebuttal testimony. Would your answers today be the same or substantially similar?
Yes.
Your Honor, I would offer what has been remarked as OPC Exhibit 212, the direct testimony of Lena Mantle, 213P and 213C, the public and confidential respective versions of her rebuttal testimony, and 214, the rebuttal testimony of Lena Mantle.
There has been 4 exhibits offered into evidence, Exhibit 212, 213, both public and confidential, and 214. All of those are the various testimonies of Ms. Mantle. Are there any objections to admission under the hearing record? Hearing no objections, so admitted. Mr. Kleiser, go ahead.
I tend to the witness for cross.
And I believe that goes to staff for cross-examination.
Staff has no questions.
And we turn to the company.
Spire has no questions, Your Honor.
Are there any commissioner questions? And I do want to state again, we have all 5 commissioners attending this meeting, either on the WebEx listening or in person. And to unmute yourself if you are on the phone is *6. So now I turn for any commissioner questions for Ms. Mantle. Hearing none, the judge has no questions. I believe you are dismissed then. Thank you, Ms. Mantle. I'm just going to announce a little bit of where we're at. We do have an audience listening again on WebEx and on the stream. This is a hybrid hearing. We are moving to our next issue, which, according to my schedule, and I'm going to look for nods, is cash working capital. Yes, it is issue 8. That will be next. We will start with mini opening statements. And Counsel for Spire, if you would give me just a second before you begin.
Oh, sure.
Counsel, please go ahead.
May it please the Commission, my name is Rachel Niemeyer, and I'm appearing before you today on behalf of Spire Missouri Incorporated to discuss cash working capital, sometimes referred to as CWC. Cash working capital refers to the net funds required by the company to finance goods and services used to provide service to customers from the time those goods are paid for by the company to the time that payment is received from customers. A lead lag study compares the differences between the company's revenue lag and expense lead. The revenue lag represents the number of days from the time customers receive service to the time customers pay for their service. The longer the revenue lag, the more cash the company needs to finance its day-to-day operations. The main issue of dispute focuses on the lead lag time for income taxes. On this issue, the company and staff are aligned in their position that the appropriate lag time is 38 days. OPC has taken a very different position that the appropriate lag time is negative 365-day lag time, and argues that since the company is not making quarterly income tax payments, the lag should be an entire year. Staff and the company agree that a 38-day lag time is appropriate and in accordance with the Internal Revenue Service's payment schedule for income taxes. Spire's witness, Timothy Lyons, who you heard from this morning, provided a lead lag study with his direct testimony, and also commented on this issue in his revenue requirement rebuttal testimony filed on behalf of Spire, Missouri. As his expert testimony shows, the appropriate lead lag time is 38 days because it is consistent with the Internal Revenue Code requirement for filing and paying corporate income taxes on a quarterly basis. Staff witness Nieto's testimony also supports this position. On page 4 of the rebuttal testimony, it states staff has historically assigned or accepted federal and state income tax lags based on statutory requirements for quarterly equal tax payments. The company asks that you decide the appropriate lag time in this case is 38 days and agrees with staff and the company. Thank you.
Thank you, and we turn to staff for their opening.
May it please the Commission. I am Ron Irving on behalf of the Commission staff. Good morning. Cash working capital is a net fund required by the utility to finance goods and services used to provide to ratepayers from the time those goods and services are paid by the utility to the time that payment is received from the ratepayers. In this case, Spire conducted a lead lag study to determine the cash working capital requirements for the company. Staff reviewed the lead lag study and made changes where appropriate. The lead lag study was used to compare the differences between the revenue lag and the expense lead. One component of expense lead is income taxes. The lead days for income taxes is determined by the midpoint of the taxing period of the quarterly scheduled payment date determined by the IRS code. The lead days is then multiplied by the estimated income taxes to arrive at the cash working capital component for income taxes. Based on the IRS code requirement for filing and paying corporate income taxes on a quarterly basis, staff would recommend that the expense lag for income taxes within cash working capital calculation should be 38 days. Staff witness Antonia Nieto will further explain lead days for income taxes. OPC witness John Riley believes that since Spire has not paid income taxes for the last 3 years, that the 38-day expense lag for income taxes should be 365 days instead. This is faulty logic, since whether the utility paid taxes in the last 3 years or not, estimated payments were still due each quarter. Thank you.
Council, I want to make sure I have a question, and I want to make sure
Yes.
it's your witness I need to ask. That last statement has me a little confused. They are required to make estimated payments?
The IRS code requires corporations to make estimated payments every quarter, yes.
Did they estimate theirs to be zero?
For the last year, staff witness will be able to answer that question.
Okay, thank you.
Any other?
No other questions. Thank you. Mr. Kleiser's opening.
I swear every time I get up here, it does not seem like this mic is picking me up, but I'm just gonna go for it. Please the commission, John Kleiser, once again on behalf of the OPC. This is perhaps one of the most ridiculous issues I feel like I've had to bring up here. You've already heard it explained, cash working capital is the amount of money that's included in rates to cover day-to-day expenses by the company. The key is that the company actually has to have an expense in order to justify including the cash in rates. In this case, the expense we're talking about is the payment of quarterly income tax, or it's actually the payment of income taxes. Staff in the company are saying the company pays taxes on a quarterly basis, so we have to include cash so they can meet those quarterly basis payments. The company has authoritatively admitted, they quote, "No income tax payments were made on a quarterly basis." That is the company's own words. They are not making quarterly income tax payments. Therefore, you should not measure cash working capital as if they are making quarterly income tax payments. If they're not making the payments, you shouldn't give them money to cover the cost of making payments. I'm just going to repeat that. You don't need to give the company money to cover the cost of making payments they don't make, that they acknowledge they don't make. This issue shouldn't be here. Once you've established they're not making the payments, you should stop giving them the money for covering the cost to make those payments. That's it. Mr. Riley has put forward what the correct adjustment is, which is a 365-day lag. Why is that correct? Because the company is receiving money from taxpayers to make the payments that they're not making because they don't pay anything to the IRS. Thus, you should treat them as if they are collecting the money and holding it for a full year, because that is exactly what is happening. The commission should adopt reality, not a fiction that has been, that's what we do in the past, so that's what we're going to continue doing. I would repeat myself, but again, to summarize, the company is not making quarterly income tax payments. You don't need to include cash working capital to cover those quarterly income tax payments. That's it. Thank you.
Thank you, Mr. Kleiser. I do have a question. It seems only fair since I previewed my witness question for staff. For the Office of the Public Counsel, my question is, what about future years?
The company is not going to pay income.
Let me back up to make sure that I understand this first before you start. Is OPC's position that they are not paying income taxes because of an NOL position?
Let me check on confidentiality for one moment, please.
Thank you. I appreciate that.
It's the OPC's position, and we believe that the evidence supports that the company is not going to be making payments, and I would strongly encourage you to ask Mr. Riley as to the exact rationale for that. But it is, in my opinion, effectively guaranteed.
Okay, thank you. No questions? We move now to witness Lyons, I believe, and he's already on screen. Let me take a moment while we all shuffle and get ready for witness testimony. Mr. Lyons, can you hear me?
Yes, good morning. Thank you.
You have already been sworn in. I just remind you of that, and that obligation is continuing. It is Spire's witness. Go ahead.
Just a moment, Your Honor. I apologize for the delay, Your Honor.
No problem.
Lyons has already been sworn in, and his testimony has already been admitted into the record, so I tender him for cross.
I believe that goes to staff.
Thank you, Your Honor. We just have one question. In your rebuttal testimony on page 4, lines 19 through 22, you state, if the commission determines in this rate case proceeding that the company has no income tax expense, then the company's cash working capital requirement related to income taxes would be 0. Does OPC's recommendation using a 365-day lag result in a 0 cash working capital requirement?
No, it doesn't.
We have no other questions. Thank you.
Thank you, and Mr. Glasser, your witness.
Mr. Lyons, you would agree with me that there is current income tax expense built into this case, correct?
Yes.
Therefore, you would agree with me that the rates approved by the commission will include costs to pay income taxes, correct?
If the expenses that were included in the direct filing were approved, then yes, there would be a cash working capital requirement.
That's not the question I asked, so let me repeat myself. You would agree with me that the rates that will be approved by the commission, if they include current income tax expense, will include money to pay income taxes, correct?
I'm not sure what the current income tax expense is. I only have the income taxes that were filed by the company, which was on the federal side, 12.4 million, and on the state side, 2.2 million, as in Schedule 2 of my direct filing.
Let me try to rephrase this yet again. If the commission approves rates that include expenses to pay income taxes, and the company collects money from customers based on those rates, the company will collect money to pay income taxes, correct?
Yes, the rates will recover dollars associated with income taxes.
Thank you. No further cross.
Thank you. I'll ask for any commissioner questions for Mr. Lyons. Hearing none, the bench does have a couple of questions, a few. Has Spire made quarterly payments during the test period out through true-up?
I'm not aware of that. I know later on there is a witness that's going to be handling all of the tax issues. So I would just kind of defer all the tax specific questions to that witness.
Which witness are you referring to?
Fire witness Chuck Cooper, Your Honor.
Thank you. And that looks like Thursday on my schedule. Okay, thank you. I'm sorry, the judge needs to take a minute. His computer has challenged him. Mr. Lyons, a corporation must have taxable income before income taxes are assessed. Is that correct?
Yes. And so let me elaborate a little bit. So the IRS publication, the one that's referenced in my rebuttal testimony, that publication 542, it basically says that if a corporation estimates that its tax for the year would be $500 or greater, then it must make estimated tax payments in 4 equal installments.
Can a corporation that pays no income tax through quarterly payments and has no carryover of excess taxes paid from prior years to be applied to the current year, can that corporation receive a tax refund?
You know, these are all really good tax questions, but I really have to defer to Spire's witness. I'm not really trained in the area of tax. I know it's a very complicated topic with a lot of provisions, and really the focus here around the cash working capital was just very simply, if the company is going to make tax payments, what is the schedule that it would need to follow relative to the cash working capital? And so from there, we can determine what is the cash working capital requirement. The nuances around what gets paid and the amounts and the carry forwards and so forth, it would be better handled by, I think, Spire's expert witness in the tax area.
Okay, thank you very much. The judge has no further questions. That does take us to recross, and we go to staff for recross.
Staff has no questions.
Thank you, and Mr. Kleiser.
No question, thank you.
And that brings up redirect.
Just a few, Your Honor. Mr. Lyons, can you hear me okay?
Yes.
Is the company's proposal consistent with the historical treatment of cash working capital?
Yes, it is. It's always looked at what the estimated payments are over the course of the year, and look at the timing of that, between that and the revenue lag.
Thank you, that's all I have, Your Honor.
Thank you, Mr. Lyons. Again, you are excused from our virtual witness stand. Please feel free to continue participating in the WebEx.
Thank you.
The next witness on my list is for staff, is that correct? Nieto, okay. And I believe it is Antonia Nieto. Can you come to the witness stand, please? Please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth? Thank you. Please take a seat. Would you state and spell your name for the court record?
My name is Antonia Nieto, last name spelled Nieto.
Okay.
Thank you, and staff witness. Go ahead.
Okay. Ms. Nieto, by whom are you employed and in what capacity?
I'm employed by Missouri Public Service Commission, and I'm a senior utility regulatory officer.
Have you caused to be prepared for the purposes of this proceeding certain rebuttal and surrebuttal testimony in question and answer form? Do you have any changes that you would like to make to that testimony at this time?
I actually do have one change. This change would be in my rebuttal testimony. The change would be on page number 4, line 7. The word rebuttal would be replaced, or needs to be replaced with the word direct.
Okay. Thank you. Do you have any other changes that you would like to make?
I do not.
Okay. If I were to ask you the questions contained in your testimony today, would your answers to those questions be the same?
Yes.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I would like to offer Ms. Nieto's testimony into evidence and tender her for cross-examination.
Thank you, counsel. I also want to stop for just a second, pause and make a quick request. On the issues that we're talking about with cash working capital, it sounded like some of the questions that the commission had would be addressed by a company witness tomorrow, perhaps under the NOL issue. The commission would request that the witnesses that we have had today on cash working capital be made available just in case we would have questions for them tomorrow. I apologize. Where we are at is staff has finished their direct. Staff has moved for the adoption of the witnesses to testimonies 119 and 136.
Correct, yes.
Are there any objections to the admission of Ms. Nieto's testimonies, rebuttal and surrebuttal exhibits 119 and 136 respectively? No objections, so admitted. The witness has been tendered and it goes to the company.
Good morning, Ms. Nieto. Can you hear me all right?
Yes.
So your position on the appropriate cash working capital expense lag for income tax of 38 days is consistent with the Internal Revenue Code, correct?
Correct.
And isn't it true that your position is consistent with staff's historical treatment of developing federal and state income tax lags based on the statutorily required quarterly equal tax payments?
That is correct.
And in this case, your position of a 38-day lag for income tax expense is the same as the company's position, correct?
Correct.
And is there a policy reason to include your staff and the company's position in this case?
The staff has traditionally used this approach to develop the expense flag for income taxes, with statutory requirements for quarterly payments.
And is it good policy to follow the Internal Revenue Service publication on cash working capital and tax payments?
Yes.
And is it good policy to follow the Internal Revenue Code on income taxes?
Yes.
Thank you. I think further.
Thank you, Mr. Kleiser.
Your Honor, I'm going to hand something out. It is currently a schedule in Mr. Riley's testimony. So I would ask that it not be marked as an exhibit, and that if Mr. Riley's testimony be offered and accepted without objection, I will have no problem. However, if there's an objection to Mr. Riley's testimony, I would like to then be permitted to offer this item which I'm about to hand out. Does that make sense?
Yes. You want to use the exhibit now and call dibs that you can ask for it to be admitted later on if there are objections to the testimony in which it is contained.
That's exactly correct.
Excellent, I'm following you.
Okay, thank you. I felt like this would help not burden the record with extra exhibits.
And I'm purposely using non-legal terms to help all of those in our listening audience on the live stream and the WebEx.
This has been marked confidential. However, the line that I'm about to discuss, I believe, is the company's way of confidentiality as to that one line.
Mr. Kleiser, say that last sentence one more time.
This has been marked confidential. However, I believe the company has waived confidentiality as to the one line that I'm going to cross the witness on.
Okay, go ahead.
Ms. Nieto, would you agree with me that this is a response to OPC data request 1312 supplied by Spire,
Yes.
signed by Charles Cooper?
Yes.
And would you agree with me that in the first paragraph, that second block under response, you follow what I'm referring to?
Okay.
The second sentence reads, no income tax payments were made on a quarterly basis?
Yes, I see that.
I'm going to do my best to avoid confidentiality. I'm going to proceed very slowly. Has staff included a net operating loss in the rates that is proposing to the company?
I believe staff has included the operating losses.
Ms. Nieto, I just want to say more clearly what Mr. Kleiser is saying. Please, no numbers.
Yes.
Okay.
And more importantly, allow time as Spire does need to raise confidentiality.
Yes, thank you. Go ahead. I'm sorry to interrupt.
I believe staff did include net operating losses, but that issue was covered by staff witness Matthew Young, and I will direct any questions about that if you would have to.
So just to be clear, if I were to ask you why staff included a net operating loss, that would be a question to Mr. Young.
That's correct.
Judge, I note that Mr. Young is also on the schedule for NOL tomorrow. Can we have the same treatment regarding Mr. Young as Mr. Cooper?
I thought your question would be to make sure that Ms. Nieto is available tomorrow.
That's a good point.
Are you wanting to ask Ms. Nieto about an exhibit that is contained in Mr. Young's testimony that you would like to?
No, I'm wishing to ask a question that I believe bears on this issue, which she has identified Mr. Young would be the appropriate person to ask. I'm not sure that it's absolutely necessary to ask this question, but may I posit this solution that, if necessary, the issue may be brought up to Mr. Young tomorrow?
Of course.
Okay. Well, in that case, I have no further questions. If I can potentially pose this question to Mr. Young, which effectively would just be, why has staff included a net operating loss, and any necessary follow-up to that?
Okay, that's kind of what I was going at. I just wanted to get the question out there. So the witness is prepared. We've all agreed that Ms. Nieto is not answering that question. I don't believe we have a question on the table.
I have no further questions.
Okay, and we have no objections.
No objection. The company is fine having a discussion on federal taxes tomorrow with our witnesses. Subject to Mr. Lyons' availability, we'll have to check on that.
Okay, moving on. Cross-examination is to the bench. Are there any commissioner questions for Ms. Nieto? And again, we do have all of our commissioners participating. If you're on the phone, it is *6 to unmute. Hearing no questions, the bench does have a couple of its own. Ms. Nieto, do you have a copy of staff accounting schedules for Spire East?
I do not have the full EMS run. I do have cash working capital schedule in front of me.
Does that include Schedule 8? the cash working capital
Accounting
requirement.
Schedule 8 is a cash working capital requirement.
My question, why not, for purposes of the cash working capital calculation, have the test year adjusted federal and state income tax offset expense be 0, when no income tax quarterly payments were made in the test year through the true-up period of the rate case? That is a long sentence. Let me try and break that up a little better. Why not, for the purposes of the cash working capital calculation, why not have the test year adjusted federal and state income tax offset expense be 0, when there is no income tax quarterly payments being made in the test year running out through the true-up period, rather than the amounts from the calculation of the federal and state income taxes from Staff Accounting Schedule 11.
So, federal tax column B in, Staff Accounting Schedule 8, that is pulled directly through income tax expense calculation staff schedule. Staff has based its recommendation on those statutory required quarterly statements, and that's how we came up with the 38 days, or agreed with the company with 38 days. In case the commission decides that OPC's argument stands, staff does not believe that 365-day lag is the correct lag to use. Staff would recommend commission consider 0 lag, which would have 0 effect on cash working capital requirements for this line item.
Okay. Are you aware of any USOA prohibition from using 0 in the cash working capital calculation?
No, I'm not.
Okay. Judge has no further questions. That takes us to recross, and that would be the company, your witness.
We have nothing, Your Honor.
Thank you, and that goes to Mr. Kleiser then for recross.
Ms. Nieto, are you familiar with the IRS normalization rules?
In general,
I asked that because I wasn't sure if this would be a question for Mr. Young yourself.
I would assume it would be.
I was thinking as much. All right, never mind. I have no further recross.
That takes us to redirect.
Ms. Nieto, OPC indicated that no test payments were made on a quarterly basis. In the future, do you know what quarterly payments Spire, Missouri will make in the future?
I would have no ways to know that.
All right, thank you. I have no other questions.
Thank you. I believe that wraps up testimony for Ms. Nieto. You are excused for the moment, and we invite you to come back tomorrow.
Thank you.
Next, I have on my witness list Mr. Riley. That seems correct. He'll make his way up to the witness stand. Mr. Riley, please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
Thank you. Please take a seat, and would you state and spell
Mr. Riley, by whom are you employed and in what capacity?
I'm employed with the Office of Public Counsel as a senior utility auditor.
Did you prepare or cause to be prepared direct testimony?
Yes, sorry.
Did you also prepare or cause to be prepared rebuttal testimony, rebuttal testimony?
Yes, I have.
And have you adopted the direct testimony of Amanda C. Connor?
That's correct.
Do you have any changes to make to your direct rebuttal or rebuttal testimony?
Yes, I do.
What changes would those be?
In direct testimony, page 8, line 17, I refer to a footnote number 6. It's incorrectly placed. It should be on line 14 at the end of the sentence. That reads, the ending of the sentence is lag is consistent multiplier in the calculation. And then it should be footnote 6.
Are there any other corrections?
The other correction is a schedule in rebuttal. Schedule JSR R-02. I have received information from the company after SIR rebuttal, which indicated to me that I needed it to recalculate the schedule. So I reapplied the numbers and the information that they gave me in their answer to one of my data requests and recalculated the schedule.
Judge, on a procedural matter, because you were taking charge of the filing of testimony, we have prepared an updated version of the schedule electronically that I can send to you and opposing counsel to facilitate that error correction.
I would rather take it as its own exhibit.
Okay. I mean, I can take it as its own exhibit. The only problem is I don't have 10 copies with me because it's a rather long schedule, and I was operating on the.
Let me back up. Does anyone have any objections to the substitution?
It's a correction not unlike any other correction that's done during testimony. It's just that you would have to do it across the entire schedule.
Right, and I would rather have the commissioners and the parties be able to see what the new numbers are and complete, rather than having to go back. I don't know what the schedule is specifically to know how that would all work. Would it?
No, I'm just, let me think on the fastest way to do this.
He has an update based on the numbers that Spire provided. I would assume we could get through offering and accepting the exhibit without the distribution, as long as Mr. Kleiser made sure to follow up by the end of business today to distribute copies.
The company would be okay with that, with the corrected. However, if there's questions about the corrected schedule, we have not seen it, so we're at a disadvantage. So we would reserve the right to inquire about that.
If I may,
Perhaps making him available tomorrow when we're having the other discussion would be sufficient.
I apologize, I did not mean to interrupt. If I may, Mr. Riley, the schedule in question concerns the gross receipts tax issue, correct?
That's correct.
Which is scheduled for tomorrow, so more than happy to do that.
Problem solved. For tomorrow, would you prepare the one whole exhibit? I'm only concerned about the commissioners reviewing that, their advisors are going to review the other parties, and myself, and flipping back through the pages, I'm just thinking given the new set.
Absolutely.
Okay,
And to be clear, I mean, if we were gonna do it the old way, he'd be up on the stand just, changing numbers on a schedule throughout the entire thing, which would have been a very tedious exercise, so.
I can envision myself interrupting that as well. I've had a couple cases where parties have filed errata sheets, and those struck me as a very lovely tool.
Right.
Let's move on.
Yes, please. Notwithstanding those changes, if I were to ask you the same questions that were posed to you in your direct rebuttal and third rebuttal, would your answers today be the same or substantially similar?
Yes, it would.
All right, at this time, I will offer the direct rebuttal and surrebuttal of Mr. John Riley, which is 209 for the direct, 210 for the rebuttal, and 211P and 211C for the surrebuttal of public and confidential, respectively. And I will also offer the direct testimony of Amanda Connor, which I neglected to pre-mark, so that would be 233.
Perhaps I'm new, or perhaps this procedure is new. I'm unfamiliar with the practice of adopting someone else's testimony and then it being a separate exhibit. Or just that you're just stating he adopted it.
For what it's worth, we actually did this earlier today when
Yep,
Mr.
right.
Reitzel adopted Mr. Sellinger's testimony. I believe they adopted it as a separate exhibit, correct?
We did.
Right, oh, I understand. I had the question then, and I just wasn't quite sure if I should ask it. But now I am. I'm just curious. We're going to go ahead, but.
Your Honor, it's the only procedural mechanism we have when a witness leaves employment of one of either a company or an agency. So, unless we wanted to subpoena them. So that's
Thank you.
a bit easier.
I appreciate that. What's the issue?
Whether it should be
Adopting Amanda Connor's 233.
Yes.
Okay. Are there any objections to the admission of exhibits 209, 210, 211P and C, and exhibit 233, Mr. Riley's adoption of Amanda Connor's testimony?
No objections.
All right, no objections. It is so received into evidence.
I apologize for all the difficulty of getting through that. I tender the witness for cross.
Okay. I am just noticing the time, 11:43. I'll just make everyone aware of that. Let's get to cross-examination. We will go to staff first.
Thank you, Your Honor. We have no questions.
Thank you, and Spire.
Thank you, Your Honor. Just a few. Good morning, Mr. Riley.
Morning.
Are you aware of payment schedules for income taxes as determined by the IRS?
I did read that in his testimony, and I had reviewed it, yes.
And by him, you mean Mr. Lyons?
Yes.
Let me give you an exhibit, which has already been marked. Yes, Inspire Exhibit 49.
So, Mark?
We're handing them out to everyone. Do you recognize what I've handed you, Mr. Riley, as IRS Publication 542?
Yes, ma'am.
I'll let everybody get it, and then I will ask some questions. Can you turn to page 6 of this document, please?
Yes, ma'am.
Do you see at the bottom right column, there's an
Ms.
estimated?
Niemeyer, I'm sorry to interrupt. Could you please move the microphone a little bit closer to your mouth? Thank you.
Yes, I can. Is this better, Judge?
Yes.
Page 6, the bottom right column, where it says estimated tax, do you see that?
Yes, ma'am.
And the following two paragraphs Generally, a corporation must make installment payments if it expects its estimated tax for the year to be $500 or more. If the corporation does not pay the installments when they are due, it could be subject to an underpayment penalty. This section will explain how to avoid this penalty. When to pay estimated tax, installment payments are due by the 5th day of the 4th, 6th, 9th, and 12th month of the corporation's tax year. Did I read that correctly?
Yes, ma'am.
So if Spire has an income tax liability, it would be subject to that schedule that I just read to you, correct?
If Spire had an income tax liability, that would be correct.
Your Honor, I move to admit Spire Exhibit 49 into the record.
Any objections to the admission of Exhibit 49? No objections, so admitted.
I have no further questions for the witness. Thank you, Mr. Riley.
And now we go to commissioner questions. Are there any commissioner questions for Mr. Riley? All right, hearing none, the judge does have a couple, and these are going to repeat a couple of the questions that I've asked previously. Do you have a copy of Schedule 8? And that's the cash working capital requirement calculation.
Yes, I have a copy.
This is the same question I asked Ms. Nieto. Why not, for purposes of the cash working capital calculation, why not have the test year adjusted federal and state income tax offset expense be zero? I'll just stop there. Why not have it be zero?
Well, if you zero out this entry, it doesn't completely take in the entire calculation. Because of tax normalization rules, and staff follows those rules, they include an amount for income tax expense in the rate case, even though the company is not paying income taxes currently. That's a requirement that we really do not get around, which is completely different than most any other expense built into the case. Even the staff had mentioned earlier that they did not include earnings tax. So basically, they zeroed it out because the company wasn't paying, it wasn't required to pay any earnings tax. However, that's different with income tax because they have to include it. So what we have is not just the fact that they aren't paying income tax, we have the fact that the money is coming in, which is different than, like I said, the earnings tax or some other expenses built into the case. It's, if you don't have an expense, you generally don't include, a payment. But with income tax, we can't get around that.
Would you, for the record, give me the citation that says you can't get around that? Is that a federal statute or a federal rule?
That would be it's footnote 2, page 4 of my SIR rebuttal.
Okay.
I quoted the IRC, Internal Revenue Code 168, I-9, capital A-I, generally referred to as the normalization rules.
Thank you.
So, to finish that up, if you just zero it out, you aren't taking into account that the ratepayer has actually put the money up. So, to zero it out doesn't give the credit to the ratepayer.
Okay, and I see where you're coming from, but you cited, as you said, the Internal Revenue Code. Does the IRS dictate the Commission's cash working capital treatment in a rate case?
If I understand that question correctly, yes, they do. Because if I understand that correctly, their IRC rule calls for, the utility to pay, actually, I guess, the, commissions to, install income tax expense into the rate. If they don't, that's a normalization violation. The IRS would, seek to, if it continued, it's not like it happens instantaneously, but, they would move to, lack of a better term, punish the company for not following their rules.
I'm having a problem following how you got to a negative. I'm with the explanation of, that a company has certain expenses. And I'm hearing you testify that one of those expenses is income taxes, and we have to account for that. I'm sorry for using the term of art, but we have to include that. What I am hearing the company and staff say is, yes, you have to include it in 38 days, because that's the day that we would normally do our quarterly payments to get our cash lined up to make those payments. And you're saying, what I'm understanding is, yes, you have to include the income tax, and we're going to account for it by acknowledging that you're not actually making any. And that's where I'm having a problem. Why didn't you go to zero? How did you get to negative 365?
Okay. If, I refer you back to the Schedule 8, we'll kind of review a couple columns.
Okay.
Because we have revenue lags and we have expense lag. Generally, revenue lag is when the money comes in from the ratepayer. The expense lag is generally when the expense is expected to be paid. So to get an idea, what I'm saying is that income taxes never get paid, but they do get collected. They have to. It's a normalization rule. Just about everybody will tell you, we gotta do that. So instead of being zero, it's got, and the expense lag has to be 365 days because of the incoming money, but no outgoing money. Now, let's look at a couple other ones that are out of the normal, and maybe it'll help illuminate why it has to be 365 days, is if you could go to line 16 in the cash working capital Schedule 8, you'll see that it's property taxes. Property taxes historically are paid at the end of the year. So we're talking all the way to the end. However, to complicate things, there's a midpoint in this sort of thing, and it ends up, the expense lag is calculated to be 185 days. Well, you can look at a lot of other things there, and we're only talking about 38 days. Now, of course, my argument is that they never get paid, so they shouldn't be at 38 days. But you can see that the cash working capital schedule recognizes late payments and early payments by its expense lag. So late payments, like incentive compensation on line 8, is 258 days. If you carry that on out, your net lag is a negative 207 days, and the cash working capital requirement is a negative $546,895. So what I'm getting at is that incentive compensation doesn't get paid for a very long time. Now, with income taxes, not only is they don't get paid a very long time, they never get paid. And we are talking about a year. This is a test year, so the entire year they aren't paid, so the entire year needs to be recognized, which is why it's 365-day expense lag, which would compute into minus 50.85, so you're at 300, 10 or however it works, and then multiply the tax amount to come up with the negative revenue requirement.
I'm confused by what I see as two topics. One being the income tax, which may or may not be paid or eliminated, and the other being the cash working capital. I am not involved in large businesses. I have no background in large businesses. My understanding, though, is that cash working capital is the amount of money a large business has to have on hand to pay whatever expenses it has in the meantime, or in the between time, until it gets the revenues or enough revenues to actually cover those bills. So kind of that middle ground, and the cash working capital is really just to help that large business allow the customer 30 days to pay and tell their supplier, I'm going to pay you this week, to be a bad example. How come you seem to be proposing eliminating the cash working capital?
Well, not eliminating the cash working capital, but because of, and this is really the only expense in the case that throws this off, is that we have to include this expense, but the expense never gets paid. So that's where that negative number comes from, is because of that. If we brought it to zero, basically what we would probably be saying is, well, you don't pay it, so we're not going to charge it. Unfortunately, with income tax, we have to charge it. We have to make the ratepayer pay. That's where that as that gets longer, as I pointed out with the 258 days for incentive comp and the 185 days for property taxes, as we get longer, that number gets bigger. And with this particular expense, because it never gets paid in the test year, it's an entire year, so 365 days. Whereas, property taxes, they're just 185. They eventually get paid. We all pay our property taxes at the end of the year. So, with incentive compensation, that Pierre, don't know much about incentive compensation, but looking at cash working capital, it doesn't get paid very often either.
Okay, I want to stop you. We're talking about the income taxes, and I want to just stop at this point. I have a question. You've said that never get paid. I'm having a problem with the word never. Mom always told me don't speak in absolutes. But my more serious question is, at some point, and maybe it is a question, maybe they won't ever pay taxes, but what is your answer to a scenario where the commission sides with you on cash working capital, Spire doesn't come in for a rate case for 5 years, 10 years, and before they come in for a rate case, something happens to trigger them paying income taxes. And all of a sudden, they're paying quarterly income taxes, and they don't have the cash working capital to cover it because they aren't effectively collecting it. We have now set up a negative 365, so they're collecting it and sending it right back out somehow. What's your solution?
Okay. Now, it's my understanding with an ISRIS, they will have to come in every 3 years.
I understand. From my example, not doing ISRIS.
Yeah. Okay, there's going to be some speculation on how that gets covered. Generally, every company comes in depending on how you want to look at it, fairly often, 4, 5 years. It's not a far stretch to understand that Spire will probably not owe federal taxes for several years. Exactly how many is subject to debate, but it appears that they will not pay federal and state income taxes before they come back in. I'm going to guess 3 or 4 years. So if they were, as you posed the hypothetical question, if they did end up having to pay taxes before they came back in, I would think there is some sort of mechanism to AAO or something like that. I'm kind of reaching here. It's kind of a legal question on that, but to acknowledge that they have a gap, so to speak.
Do you see that as the responsibility of the commission when setting just and reasonable rates and making sure to set the utility in a position where it can attract capital and continue operating? Are we setting the utility, would the commission be setting the utility up in a good position, meeting all of those requirements, if it allowed Spire to go forward without a mechanism to pay income taxes?
I would say that adjusting cash working capital to reflect the collection of income taxes, which will be in rates, and acknowledging that they don't pay them would not really affect their ability to attract capital. I don't think correctly identifying this particular issue as a game breaker. I think the correct way to do it is to acknowledge that money's coming in and not going out, which is how the 365-day expense lag recognizes that.
I'm going to just make a general statement to see if you agree. The amount of money that's in the cash working capital is too much because it currently accounts for taxes. The company does need a cash working capital system, and we need to lower that number somehow. Would you agree with that?
Well, I'm feeling like you're confusing the actual collection of income taxes, which they'll get each year, over the course of the entire year, with a calculation of cash working capital, which, according to my calculations, would be negative. However, that doesn't mean they don't have the money. The cash working capital is a recognition of who's paying for this expense first. It's not a question of is the expense getting paid. It does get paid. Well, income taxes aren't getting paid because it's just how that.
The bucket of money is there.
Who's paying it first?
Okay.
Ratepayer or the shareholder.
Okay.
So what we're looking at here is that the ratepayer is paying this money all year, and it never goes out. It gets kind of confusing, but you don't want to confuse the fact that rates are set here and this calculation of cash working capital, because that is a function of who's paying it first. And with this particular argument that I have on federal and state income taxes, the ratepayer is paying it first, and in fact, the ratepayer is the only person paying this because it never goes back out. So it's all built in. You look at it and you go, my gosh, the cash working capital requirement's going to be negative, but we are talking about cash working capital. It's just a funding mechanism as opposed to a real expense. Like I said, this is, who's paying it first, the ratepayer or the shareholder? So it's, in that context, it's not really going to affect the funding that much.
So my true question, if I was following the actual dollar, would be ratepayers are paying it each month. Spire is collecting it. My question should be, what is Spire doing with that category of collections? Are they waiting, is that earmarked, for lack of a better word, for taxes, and we're just waiting until that event happens? Or is this not a question for your area? I know this might be quite off topic, so.
It might be, I mean, I could probably answer it, but it's probably a question for tomorrow.
Okay. Thank you, sir. Let me see if I have any others. Are you aware of any USOA prohibition from using zero as the cash working capital calculation?
I'm not aware, no.
Okay, I have no further questions. You're not excused yet. This takes us back to recross. We start with staff.
Thank you, Hunter. Ms. Riley, are you aware of any other non-cash cost of service components in the cash working capital schedule that has a zero cash working capital requirement? Would you like me to restate that?
Go ahead and repeat that if you would.
Are you aware of other non-cash cost of service components in the cash working capital schedule that has a zero cash working capital requirement?
Well, staff has included bad debt as a neutral expense. There isn't a cash component to bad debt. It's a lack of cash, I guess, but that would be that's a zero requirement, cash working capital. And then I had mentioned city taxes before. They weren't collecting them, so they zeroed that out.
Okay, so you would agree that bad debt has a zero cash working capital requirement? So you would agree with that?
Yes, I'd have to agree with that.
One last question. Would you also agree that for non-cash components, that the customer pays in rates with no company cash outlay? For
a non-cash
component,
the customer pays?
that the amount would go into rates?
Well, there's a calculation for bad debt, yeah.
I have no other questions.
Spire?
Thank you, Judge. Just a few questions, Mr. Riley. Congress can change the tax code anytime, correct?
I'm not an expert on what Congress can do, but I'm sure they can probably pass a law pretty quick if they care to.
And if they pass that law, corporations are required to follow the law, correct?
That would be correct.
And if the company started paying quarterly taxes, would 38 days be the correct lag for income tax?
If they were paying?
Yes.
I haven't argued that.
I'm asking you if that's correct.
If they were paying, then 38 days would probably be correct.
Thank you. And would you agree that the, normalization rules are designed to incentivize the company to invest in the into capital projects,
I would probably agree with that, yes.
and that a violation of a normalization rule is, the company would receive a penalty? Do you agree with that?
That's a direct possibility, yes.
I have nothing further, Your Honor. Thank you.
Thank you, and redirect.
All right. A couple things we'd like to cover. First, I think this was hopefully cleared up, but there was some confusion when you were talking to the judge regarding the difference between current income tax expense and cash working capital to pay income tax expense. You recall that confusion?
Yes, sir.
Those two things are different, right? Can you explain the difference? Just do that.
Well, income tax expense is built into rates, and they are collected. Now, they're collected, you know, as rate making goes, they're collected all year. Now, with your revenue and expense flags, it's calculated, you know, how much, when it's coming in from the ratepayer and when it's going back out. So when you're talking about income tax expense, you're talking about rate and an annualized amount. When you're talking about cash working capital, you're calculating how much money the company actually needs in order to pay daily expenses or weekly expenses. Whereas my basic contention is they don't have an expense to pay.
Here's the critical question. Of those two buckets, which are actually meant to pay the income taxes due to the federal government? Current income tax expense or cash working capital?
To actually pay, it would be in rates. I'm a little confused because cash working capital doesn't pay there's no income tax expense to pay.
If the company was going to pay income taxes, the money to pay that income taxes is collected to which? Current income tax expense or cash working capital?
Current income tax expense.
Thank you. Here we go. So your adjustment to cash working capital will not affect the amount that they're collecting to pay income taxes.
No, it will not.
Here we go. All right. The judge asked a lot of questions about, are we setting the company up for a bad time? You know, they're going to come back in 5 years. What happens if they start paying? You had questions. Do you recall that?
Yeah.
You had questions from Spire about what happens if the law changes. Do you recall that?
Yes.
Is there a mechanism by which a company can request a change to its rates if it needs to?
I would think that if we would get Congress changing the tax laws that would require Spire to, well, in fact, we had the 2017 tax law change.
What is this case we're in right now?
Well, this is the general rate case.
Right.
So
if the company needed to get more money because something in the calculation of their current rate was wrong, could the company come in for a rate case?
yes,
And you mentioned the ISRIS in your response to that. Your understanding is the company's going to come in every 3 years for that ISRIS?
that is my understanding.
Mr. Riley, is it your understanding that the company currently has a net operating loss carry forward balance that would prevent them from having to pay income taxes for the next 3 years?
That is my understanding, yes.
So it is highly unlikely that the company will need to pay taxes for the next 3 years.
Very unlikely.
All right. You were asked questions by the judge trying to get to the understanding of why you were excluding the cash working capital. for tax, for income tax expense. Do you recall that line of questioning?
Yes.
I feel like part of the problem here is that cash working capital for income tax expense was being taken in isolation. Cash working capital, at the end of the day, is a single adjustment to rate base, right?
Yes, it is. It's included in that schedule as a line item.
And as we can see from the schedule, there's positives and negatives all across it, right?
Yes.
So what we're looking at the end of the day is just the total amount of money the company needs to have on hand to meet all of its obligations, right?
Yes, that's correct.
So, the income tax expense being just one component of that is a potential offset to other components, right?
Yes, sir.
And having a negative cash working capital overall, that's effectively just like the ratepayers are giving a loan to the company to meet day-to-day expenses. Is that a fair way to phrase it?
That would be a fair way to phrase it.
Now, there was a lot of questioning about setting cash working capital to zero. Let's split this up because it's important. You could set two different numbers to zero. You could set the expense lag to zero, or you could set the actual dollar amount that's being included to that issue to zero. Do you agree with that? Well, let me say, is that two different ways that you could approach the issue, not what you should do?
You could approach it that way. What company and staff have proposed is that zero it out, which would make the revenue and expense lags equal.
And you believe that would not be fair to customers for what reason?
Well, because the customer in their rates, it's built in the rates, so it's it's an increase in rates by the amount of income tax, and they're paying it. And the staff in the company would like you to think that, well, if we set it to zero, that's okay. That just kind of makes it all right. We don't make any adjustment to cash working capital. But the ratepayer is paying, so they're not getting any benefit out of that. If you're looking at it to set it to zero, as opposed to say, I'm footing the bill, it's me, the ratepayer, paying for this, and you're just gonna pretend it doesn't exist by making it zero. Whereas it should be a negative adjustment because of the incoming money and no money going out. So it should be, and mind you, it's, if you go with this, which I believe you should, no way do I ever think it should be zero because of how much money they're paying. But yeah, the commission accepts my argument, cash working capital will be negative. I mean, because income taxes are a huge expense. It's big, it's basically $40 million. So it never gets paid. So that calculation is big. Everything else is, there's some large numbers in there. There's purchase gas costs at $10 million, there's $7 million for payroll and that sort of thing. But those things all have a ratepayer paying and a company spending. Whereas in this case, I mean, unless we want to suddenly decide we need to change the calculation formula of cash working capital because there's going to be a little bit of pain, and it is just a little bit of pain that the company's going to have because of a big negative number for income taxes, then, I just don't think that's right.
That brings me to my next question, because you were asked across by commission staff about other items in the cash working capital calculation that had a zero. Do you remember that?
Yes.
But your position is that cash working capital for income taxes is unique. I believe you sort of answered that, but let me redirect and ask you to more clearly elaborate on that point.
Well, yes, cash working capital is unique. They mentioned a bad debt, and there's a calculation in there that of an estimate of how much the bad debt will be. But there's not a cash outlay, which is why that's zero. But with income taxes, like I said, with earning taxes and the city taxes, staff has recognized that Spire doesn't spend any money on it, so they zeroed it out. They just said, okay, we're not putting this in cash working capital because you don't have to spend any money. So you also don't have to collect it. That's an important point there, is you have things that you don't spend money on, but you don't have to collect either. That is the big difference between income taxes, because income taxes have to be collected. That's the big throw there. That's the 365-day number, is because they have to collect it. Can't get around it. If you get around it, you just make it zero, but you can't.
And they have to be collected because of the IRS normalization rules, correct?
Yes.
I apologize for that. I will get closer to the mic. And when you were asked a question by the judge about whether the IRS dictates commission rules, there will be very bad consequences if the commission deviates from those normalization rules, potentially, correct?
That's my understanding. Spire would face the brunt of Internal Revenue Service.
I have no further redirect. Thank you.
Thank you. The time is 12:22. I intend to break for lunch right now until 1:30. Excellent. We're on recess at lunch until 1:30. Off the record.
Oh, it's too late now. I was going to say,
the live stream has been turned back on, as the audio for the WebEx. We have finished 2 of our 3 issues scheduled for today. Our last issue for today, and I do not intend to bump up the schedule to try and fit more issues in today. I plan to end with incentive compensation, but I do plan to finish incentive compensation. This is issue 13 for those listening on the streaming or on WebEx. We have scheduled witnesses, but first we will be going to our mini opening statements, and we will begin with Spire.
Thank you and good afternoon, Judge. Spire believes that incentive compensation plans are an integral part of a majority of corporations' total compensation package. Base salary, short-term incentives, long-term incentives, health and wellness plans, as well as retirement and savings plans are important tools to recruit, motivate, incent, and retain a talented and qualified workforce. In the fall of 2018, Spire's management conducted a detailed review of the company's current annual incentive plan design, sometimes referred to in this opening statement and throughout the day as the AIP. That review focused on the utility's then current business unit metric, which was utility operating income. After considerable review and discussion by Spire management, the decision was made to eliminate this metric for all non-officer plan participants and establish 2 new metrics. The first one is utility contribution margin, or non-gas revenue. The second, utility adjusted O&M per customer. These 2 new metrics offer benefits that impact both our valued customers and our employees. Spire believes that these customer-focused metrics contribute to more affordable rates for our customers while aligning and complementing Spire's customer satisfaction and safety metrics. Overall, Spire feels this change reinforces our continued commitment to continuous improvement and creates better lines of sight for our employees and our customers. These new metrics incentivize employees to reduce expenses or increase revenues while providing safe and reliable service, which safety and customer service is also measured. Staff agrees that Spire's 2 proposed metrics should be implemented. In its cost of service report, staff included a level of non-earnings-based AIP expense that staff believes will be representative of Spire's incentive compensation expense for the year following this rate case. OPC will argue, however, that no amount of incentive compensation expense should be included in Spire's cost of service. OPC's position is not supported by the evidence and is contrary to the Commission's long-standing precedent of allowing inclusion of non-earnings-based incentive compensation to be recovered in a regulated entity's cost of service. Unless there are any questions, that's all I have.
Thank you, Council. No questions. Let's move on to staff's opening.
May it please the Commission, Chris Stokes for staff, and the Commission's lead, we would like our Rule 13 student, Natalie McKernan, the 3rd-year law student at the University of Missouri School of Law, to provide our opening statement.
Leave granted. Ms. McKernan, please.
May it please the Commission. Good afternoon, Chairman Silvey, Commissioners, and Judge Hatcher. My name is Natalie McKernan. I am a Rule 13 law student, and I represent the staff of the Missouri Public Service Commission concerning the issue of incentive compensation in this proceeding. Staff recommends a level of non-earnings-based annual incentive plan, or AIP expense, to be included in rates. Staff believes this to be representative of Spire's incentive compensation expense. Staff further recommends that the 2 new metrics implemented by Spire in 2018, utility contribution margin and utility adjusted O&M per customer, be included in rates because the metrics provide benefits to ratepayers by incentivizing employees to reduce expenses or increase revenues while providing safe and reliable service. Staff is recommending that only non-earning-based AIP expense be recovered through rates because the Commission has previously found that Earnings-based incentives primarily benefit shareholders. If a utility wishes to employ an earning-based incentive plan, it is welcome to do so. However, because such plans primarily benefit shareholders, it is shareholders that should bear the cost of such plans. Staff witness Jeremy Juliet is available today to answer any questions you may have as to how and why Spire reached its recommendation in this matter. I implore you to ask him any questions you may have about the risk of double recovery. Mr. Juliet can help you understand that such assertions regarding non-earning-based incentive compensation are unreasonable. Thank you.
Thank you, Ms. McKernan. Excellent job. No questions. We'll move on to the Office of the Public Counsel.
If it would please the Commission, John Kleiser on behalf of the Office of Public Counsel. Inclusion of the cost of incentive plans is not necessary in rates because a properly designed incentive plan will produce earnings that exceed the cost of the plan itself. This means the incentive plan will pay for itself through positive regulatory lag. Because it will pay for itself, it is not necessary to have customers further pay for it by including it in rates. Let me give you an example. Imagine, if you will, a small distribution company with local regional offices. One office in particular is allocated a budget of, say, $1 million. This office has a manager, and they have a policy that if the office comes in under budget, the manager gets to retain 5% of the difference. So, for example, if this office in 1 year comes in under budget of, say, $900,000, the $100,000 difference, there is a $100,000 difference. The officer retains $5,000, $95,000 goes to the company. That $5,000, that's the incentive plan. But you see it works out in the company's interest because they're getting the $95,000 difference. Spire is no different. Right now, you're going to have a bunch of costs built into rates. The incentive plan will reduce those O&M costs, but the company will still earn the money for them through rates from customers. That increase to the company's bottom line, generated because it's reducing its expenses while still collecting them, will pay the cost of the program. So you don't need to include the cost of the program in rates. This is basically the entire argument for the OPC's perspective. And unless there's any question, well, there is one other issue I would address, and that is we believe that the plans are not known and measurable because they can be discontinued at any time, and there's a lot of variables involved. But between these two issues, we would ask for the Commission to not include the cost of incentive plans being raised. Are there any questions?
No, thank you, Mr. Kleiser.
Thank you.
We'll go to our first witness, Mr. Weitzel. As he makes his way up, we'll take just a moment for some technical setup. Mr. Weitzel, you have already been sworn in. I am just reminding you, you are still under oath.
Thank you, sir.
I tend to the witness, Spire's witness.
Thank you, Judge. Mr. Weitzel, since your testimony has been sworn in and you're under oath, I will tender you for cross-examination.
Thank you.
Staff.
Thank you, Judge. No questions.
Thank you, Ms. McKernan. And Mr. Kleiser.
Thank you, Your Honor. Good afternoon, Mr. Weitzel.
Well, sir,
Would you agree with me that a prudently developed plan will generate more in benefits than it will cost?
what do you mean by benefits?
Reductions to O&M, increase to revenues.
Increase the customer service would be included in that, or safety?
Sure.
Okay. Yes.
The benefits achieved are going to be greater than the cost of operating the program. You would agree with that?
Sure. Yes.
So let's talk about benefits stemmed from reductions in, well, would you agree with me that benefits that come from these incentive programs include reduction in expense or increases to revenue?
Yes.
And you would agree with me that expenses and revenues are currently fixed in rates during a rate case?
Yes.
So if the company increases revenues from what's in rates or decreases expenses from what's in rates in between a rate case, that's going to create earnings for the company, correct?
Not necessarily. When we're talking, revenue, you could have a lot of revenue and make $0. Uber is one of the largest companies, and they might have just turned a profit. So, earnings tied to revenue is not a direct correlation. And, keeping expenses low would, without having any revenue, isn't necessarily tied to earnings either.
If a company's revenue, if Spire's revenue increases above what's set in this rate case with no other changes, all else things being held equal, will Spire have increased its earnings?
Minus tax and ADIT and all that, all else, then directionally, I could probably agree with you, Mr. Pfeiffer.
Right. Whatever increase in revenue will go to Spire's bottom line. You would agree with that, correct?
If we're just talking revenue and all else being constant, which isn't in reality of utility operation, I'll agree with you.
And if Spire's expenses, as they were built into rates, were to decrease with everything else being held constant, that would increase Spire's earnings, correct?
All else being held constant, equal, I could probably agree with you, Mr. Pfeiffer.
And the more that you increase revenues, or the more that you decrease expenses, the more effect it will have on earnings, correct?
Can you repeat that question, please?
The more the company increases its revenues or decreases its expenses, the greater the effect will be on earnings, correct?
Judge, I'm gonna object to this. I think this question's been asked and answered multiple times.
If I may respond, I'm really just trying to tie the fact that the greater the impact will be. That's the key that I want to get in there. I can attempt to rephrase, but I don't really know how, to be honest.
Has the witness already testified to the greater effect?
Let me try and move past it, okay? I think I can try and move past this. So would you agree with me that if a prudently incurred plan generates more revenue for a company than what's in rates, than it costs the plan to operate, it will generate more earnings for the company than it costs plans to operate, than its plan costs to operate.
Yeah, I'm just getting tripped up here, Mr. Kleiser, because you're focused on one element of our plan and not the plan in totality. And when you're talking about all moving parts of revenue and expense, I'm not seeing the connection or correlation.
Look,
So maybe rephrase it for me, please.
one of your plans involves reducing O&M expenses, right?
That's correct.
And if you reduce O&M expenses than what's beyond what's currently in rates, you're going to increase the company's earnings.
Not necessarily.
Do you have a copy of Mr. Juliet's historical testimony in front of you?
I do not. One I'm missing.
Sure.
Thank you.
Can you turn to page 10 for me?
Yep.
Would you see that at lines 10 through 11 on page 10, Mr. Juliet says, yes, reducing expenses and increasing revenues would increase Spire's bottom line? Do you disagree with this statement by staff witness?
Yeah, I'm gonna finish the rest of his answer there, and then I'll let you know if I agree. Yes, reducing expenses and increasing revenues would increase Spire's bottom line. However, the method employees use to reach these targets benefit ratepayers.
I agree. But the important part here is that it will increase Spire's bottom line. You agree with that? Well, I believe you already have agreed to that.
Yes.
Turning to lines 17 through 18. Yes, any incremental cost reductions that occur in between general rate cases would increase Spire's earnings. Do you disagree with that statement?
Yes.
And if we've already established that a prudently,
All else being held constant with revenue.
we've already established that a prudently designed plan is going to generate increased revenue or decreased earnings greater than the cost of the plan, correct?
Can you repeat the question, please?
The irony is I believe I already have asked this question at the beginning. A prudently developed plan will generate greater increased revenues or decreased expenses than the cost of the plan itself.
Do you want me to confirm that statement?
Yes.
Okay,
Is that a yes, or are you thinking about it?
I'm thinking about it.
Okay.
The third time might be a charm, Mr. Kleiser. I apologize for your repeating.
Would you agree that a prudently, let's start that question over just so I can get this straight. Would you agree with me that a prudently designed plan would increase revenues or decrease expenses by an amount greater than the cost of the plan itself?
Yes, there needs to be, in designing a plan, there needs to be an ultimate benefit.
Okay. All right, no further cross, thank you.
Thank you, Mr. Kleiser. That brings us to commissioner questions. And again, we do have commissioners listening both on the live stream and on the WebEx. If you need to unmute, that is *6. If you're on a phone, are there any commissioner questions for Mr. Weitzel on the issue of incentive compensation? That's issue 13. Hearing none, the bench does have a couple questions. I'd like to follow up just a bit on Mr. Kleiser's last inquiry.
Okay.
I heard a lot of absolutes in his question. And I'm wondering if your consideration included perhaps the expenses of implementing the program, or unintended expenses or lost revenue that are tied to the program but weren't planned for. Is that what your hesitancy was?
Yes, it's, the questions were absolute and in a vacuum. And these are intended to reduce costs for our customers, so that you don't have to see us as much as you need to in this hearing room or a rate case. And so, that's a component. Making sure that our customer base is growing is a component, so that our revenue is not shrinking, so that there's not limited customers to spread any cost to them. More customers is a greater base to spread these costs out. And so when you look at all of our components, and these are just two of our components of many, maybe just 20 to 30% of our total incentive compensation that's been discussed with the Office of Public Counsel. So when you look at all these moving parts in totality, it paints a lot different story than just earnings-based, revenue-based. There's balance there, and that's why it's designed that with the customer in mind. And we made these changes after last rate case because we heard what the commission said, and we wanted to be that focused on benefiting the customer.
Would you explain for the record why Spire should be earning a rate of return on a program that, as Mr. Kleiser suggests, if it works as it's intended, would already save the company money?
And I believe, I'm not an accountant by trade. This is an expense. I don't think for union folks, we might be capitalizing some of this incentive. I don't know, Judge, right now what we're doing for the common rank and file, but a lot of this is expense and not necessarily earning a return on these programs.
Okay, thank you. I have some other prepared questions. I'd like to ask about your direct testimony. Do you have a copy?
Yes, sir.
And I'd like to turn to page 23.
Okay.
You state that Spire Management conducted a review of the AIP that was focused on the utility's business unit metric.
Mm-hmm.
Can you define the utility's business units whose employees participate in the annual incentive plan?
Yes, these are utility employees that participate in this, specifically Spire, Missouri in this case.
All of the business units within Spire, Missouri?
There is a utility business unit that looks at all regulated utilities in the state, people that work for gas utilities.
Okay.
Excluding all the other entities or affiliates that Spire Inc. has.
I see. How is the new utility contribution contribution margin metric different from the prior utility operating income metric?
The utility operating income is closer to what, some of the questions I got from the Office of Public Counsel. It's looking at revenue and expenses together, and that's your income. That is more earnings, profit, revenue base. This breaks it down, to make it easier for our employees to achieve. They understand laying new pipe, connecting new services, retaining customers. Again, in the spirit of having a solid and growing customer base to further spread any costs out than a decreasing customer base. And so this looks at non-gas revenue only, which the big driver of that is any type of customer growth.
Have the new metrics been in place for Spire's fiscal year beginning October 1, 2019 through the current period ending May 31st, 2021?
I believe that's correct, Judge. Definitely during this test year.
Okay. And going back or staying on page 23, how is the utility adjusted O&M per customer metric benchmarked or compared to prior periods, and what type of reduction in the metric is required for bonuses to be paid to employees?
We look at the previous year. There could be an inflation index to that, 2 to 3%, but it's looking at those expenses in that operation. Property tax is involved in that, because we're trying to keep expenses down for our customers as much as we can. And once you add up the customer, but divide it by the customer base, our total customer base, that gets you the O&M per customer. And so we look at maybe an inflationary index to the previous year, and that's kind of our benchmark of maintaining expenses. And that's one of the highlights in this case, is we've tried to maintain expenses, I think, to about 1.7% a year, in trying to manage 2 to 3% pay raises or other benefits that are going up substantially. And that's trying to reflect in there and keep our employees focused on those expenses.
That leads perfectly into my next question. How do the employees have the ability to influence the utility contribution margin metric, since it is fundamentally dependent on revenues?
Well, can you repeat that, Judge?
Absolutely. How do employees have the ability to influence the utility contribution margin metric?
I kind of alluded to begin with is retaining customers. A customer calls in the call center, struggling, offer programs, try to keep them on the system, see what we have. Also, new business and expansion, talk to builders, talk to developers, see where it makes sense for Spire to overlap with that and increase our customer base. And when I say that, you've got business development groups looking at that, you've got engineering groups looking at that, regulatory's been helping out with CCN, so there's a lot of teams that could help and assist some of these goals.
Okay, this is going to be a hypothetical. Okay. Example is, if O&M were $1 million and the customer count was 10,000, the metric would be 100, meaning each customer required $100 of O&M. If O&M fell to 800,000, the metric would be 80, assuming customer count stays the same. Would that justify bonuses of up to $100,000 savings, the 800 to 1 million, would that justify bonuses of up to 100,000 or as high as 200,000, all of the savings?
I never thought about it like that. I think that spread in savings would be justifiable. So, in your example, the 800,000 to the million.
So it would justify bonuses of the 200,000, the saved money. Okay. I have two more. Why are property taxes included in this metric?
That, I don't have all the background information on that. I think it's just keeping an eye on a large expense for the company, making sure that we're watching tax rates. We're involved with that, with property tax. I know there's previous cases going on right now where people are trying to increase 20, 50% of some of our property tax base. So we're trying to manage that expense for our customers, and I think that's probably why it's in there.
You said employees are trying to manage our property tax base.
Yes.
Can you expound on that? Is that increasing your property holdings?
Increasing our property taxes, and this goes to legacy appeals or legal property tax debates that I'm not necessarily close to. But again, if all of a sudden your property taxes increase 50%, Spire could be like, okay, we're done, pass on. But we're involved in those disputes. We're trying to educate on why that would increase, and so I think it's just another form of expense they're putting in there for everyone to be mindful of.
It brought up a question for me as I was reading over the testimony, only because this case also had, at one point, I think it's on the settled issues list, the Kansas state of Kansas tax tracker was an issue. And as I recall the testimony, it boiled down to Kansas assesses the tax on the holdings as of January 1st. So if Spire got caught with a large amount of gas in one of their storage areas, then there would be a very unusual and very large property tax bill. And that got me thinking to this issue, because now we're including property taxes as part of that employee incentive. I didn't know if the two were related.
I would say probably not on that one.
Okay.
I think this is more county property value of our pipe in the state of Missouri than that specific issue, Judge.
Okay, thank you very much. Let me see where we're at on my list. Last question from me. Does the 12-month average customers use as the denominator in this metric, does that include all rate classes or just residential?
I don't know, to be honest with you, Judge.
That's okay.
We could try to follow up with all parties.
It sounds like we'll be back tomorrow, so we can just put a pin in it, not a problem. As I said, that was all the questions I have. We now have recross. Let me think through this. Recross, we go to staff. Ms. McKernan.
Thank you, Judge. Staff doesn't have any questions.
Thank you. And Mr. Kleiser.
Yes. Mr. Weissman, you were asked a question by the judge regarding an example, O&M reductions. Do you recall that example?
Yes.
Okay, and I might need to rely on the judge if the numbers come up, because I didn't have the exact numbers written down. But would that example have justified bonuses of $300,000, an amount greater than the savings.
I could see where that'd be called into question.
Okay. Going back to the very first question you were asked by the judge, the other expenses. I think there might be some hang-up on the term earnings, and I can understand why. So let me back this up and ask it a lot simpler. Your O&M plan, is it going to generate cost savings for the company greater than the cost of the plan itself?
The way that we see this, it's per customer, and not total O&M savings, so I would have to see what that net savings is. When we look at it, it's per customer, so 200, 300,
You don't know if the plan you're proposing might actually end up cost customers on average in the aggregate more than they'll see in savings?
I would hope not, Mr. Kleiser.
You would hope that the plan in the aggregate would generate cost savings greater than the cost of the plan itself, right?
For an O&M reduction, yes.
Right, and for the other one, the utility contribution margin, that should increase company revenues, right?
Correct.
And it should increase revenues by more than the plan costs, correct?
An ideal incentive comp makeup, yes.
You say ideal. Wouldn't it be imprudent to have a plan that doesn't generate more revenues than it costs?
That would be a problematic incentive compensation plan.
Right, so we would agree that a prudent compensation plan is going to generate more revenues than it costs upfront.
Or reduce expenses.
Okay. And I think we already covered this, but just to be sure, no, never mind. We've already covered it. I don't need to ask that question. I have, do you know how much the company increased or decreased its O&M costs in this case due to the 2021 incentive plan?
The 2021 incentive plan is not out there yet for us.
Thank you. I have no further questions.
And back to the company for redirect.
Just 1 minute, Judge.
Go ahead.
No redirect.
Thank you, Mr. Weitzel. You are excused for the moment. I think I saw your name for tomorrow, so we'll see you then.
All right.
We move now to witness Jeremy Juliet for staff. If he could come on to the witness stand. Mr. Juliet, please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. Please take a seat and state and spell your name for the court reporter.
My name is Jeremy Juliet. My last name is spelled Juliette.
Staff's witness, Ms. McKernan.
Good afternoon.
Good afternoon.
By whom are you employed and in what capacity?
I am employed by the Missouri Public Service Commission as a senior regulatory auditor.
Are you the same Jeremy Juliet who contributed to the cost of service report?
Yes.
Are you the same Jeremy Juliet who filed rebuttal and rebuttal testimony in this matter?
Yes.
Do you have any additions or corrections regarding the cost of service report or your filed testimony?
I do not.
And if I were to ask you about your contributions to the cost of service report, would your conclusions be similar or substantially similar?
Yes, they would.
And if I were to ask you the same questions contained in your rebuttal and your rebuttal testimony, would it be similar or substantially similar?
Yes.
Are your conclusions and answers true and correct to the best of your knowledge and belief?
Yes, they are.
Staff would like to offer the rebuttal testimony of Jeremy Juliet as exhibit number 112.
Did you want to do both exhibits at once? Or-
Yeah,
Okay,
I was gonna do both. And then staff would also like to offer the third rebuttal testimony of Jeremy Juliet as exhibit number 131.
all right, thank you. Council, you have heard the request for admission onto the hearing record of Exhibit 112 and Exhibit 131. Do I hear any objections? Hearing none, those two exhibits are admitted onto the hearing record. Go ahead.
Thank you, Judge. At this time, I tender the witness for cross-examination.
Thank you, and I believe we go to the company, Spire, next, or across.
Thank you, Judge. We just have a few questions. Good afternoon, Mr. Juliet.
Good afternoon.
How are you today?
Good, how are you?
I'm good, thank you. So in staff's cost of service report, you included a level of incentive compensation expense that you believe is representative of Spire's incentive comp expense the year following this rate case. Is that correct?
That is correct.
And that level that you included did not include any earnings-based compensation.
That is correct.
And removal of earnings-based incentive compensation is consistent with long-standing commission precedent, correct?
Correct.
But the commission does routinely approve incentive compensation expense that's based upon consumer or operational metrics, right?
That is correct.
And it is staff's position the two new metrics proposed by Spire are based upon consumer or operational metrics?
Yes.
Do you believe that they should be approved by the commission in this case?
That is staff's recommendation.
Thank you.
Thank you, and Mr. Kleiser.
Good afternoon, Mr. Juliet.
Good afternoon.
Is it staff's position that once the company has achieved a benefit, either from cost reduction or revenue increase, it needs to annually pay the same incentive to the employee who achieved the benefit in order to maintain the benefit?
Can you repeat that one more time?
Absolutely. Is it staff's position that once the company has achieved a benefit, either from a cost reduction or a revenue increase, it needs to annually pay the same incentive to that employee who achieved the benefit in order to maintain the benefit?
Staff's recommended level of incentive comp is to incentivize employees to capture additional savings. And so each year, it's incentivizing employees to capture further savings past that year previously.
New benefits, right?
Correct.
Okay, so let's run this down to make sure we're clear. Let's say I work for Spire, I do something that lowers O&M costs by, say, $30,000. I receive a bonus as a reward. It's not your position that I should keep receiving that same bonus indefinitely as long as I work for Spire, and the customers should keep paying for it, right?
Explain that one more time, sorry.
If I generate a benefit by reducing O&M, I get a one-time bonus. I don't keep getting the same bonus year after year.
The expectation is that you would continue to attempt to get more savings.
Right, incentive payments are paid out once, you have to generate new savings in order to get another further incentive benefit.
That is correct.
Okay. So the benefits that have already been achieved, they're built into rates, we don't need to worry about them, right?
And when you say benefits, you're talking about the cost savings?
Either reduced O&M or just reduced costs or increased revenue. Either way, the ones that have already been achieved, they're already in rates, we don't need to worry about them.
As long as they're in the test year, yes.
Yeah. We don't have to include costs to pay for those benefits we've already achieved. We're looking for costs to achieve new benefits, right?
That is correct.
Okay, would you agree with me that a prudent incentive plan will generate more earnings for a company than the plan costs to run?
Yes.
This is a long shot. Do you have a copy of staff rebuttal testimony for witness Nieto, who's whose first name I will mispronounce if I attempt to say it.
No, I do not.
Could you hop on EVIS right there and pull it up?
I can't, or if someone has a copy. Bear with me.
That's the surrebuttal of Nieto, which was introduced into the record earlier today.
We have a paper copy coming forward. Thank you, Mr. Kern.
Thank you. Could you turn to page 6 of Ms. Nieto's surrebuttal testimony?
Nine.
All right, at lines 6 through 7, would you agree with me that this reads, regulatory lag, simply stated, is the time between the incurrence of a cost or revenue by utility and the reflection of that expense or revenue in rates?
You're asking if that's what it states? Yes.
Do you agree with that definition of regulatory lag?
Yes.
Okay, so in your surrebuttal testimony, you acknowledge the fact the company is going to increase its bottom line in between rate cases because of the incentive plan. Do you agree with that?
Yes.
Would you qualify that increase to bottom line as regulatory lag?
If, as my surrebuttal stated, if the company recognizes revenues greater than what is built into rates, then yes, they would get to keep that in between rate cases.
So would you agree with me that we can use the term positive regulatory lag to describe that phenomenon?
Positive for the company?
Yes.
Yes.
All right, so on that same page of Ms. Nieto's surrebuttal, at lines 19 through 22, it reads, in this case, the company could have experienced what's commonly known as a positive regulatory lag, meaning that by the time current rates are changed from this rate case, Spire will have recovered directly in rates more dollars from terminated employee salary and benefit compensation than experienced in severance costs. Do you agree with me? That's what that says?
I would just change the use that experienced and it says expended in severance costs.
Thank you.
Other than that, yes, I agree.
Okay. And are you aware that a staff position, severance costs not be recovered?
In general, yes, I'm aware of that.
Okay. No further cross. Thank you.
Thank you, Mr. Kleiser. That brings up commissioner questions. Are there any commissioner questions for Mr. Juliet? All right, hearing none, the judge does have a few questions. Mr. Juliet, when does Spire pay out the bonuses associated with the short-term AIP incentive plan?
From my understanding and review of the paperwork, it would be, so their fiscal year ends September, and typically it's paid out, I believe, in November of that same calendar year, but different fiscal year. So it'd be the beginning of the next fiscal year.
Okay. When does the annual short-term AIP incentive plan start each year?
I believe this is with the start of each new fiscal year. So it'd be
October 1st. What short-term AIP incentive plan years were reviewed for this rate case?
It would have been the test year.
Okay. Does that mean that the AIP bonus payouts that we just identified occurring typically the following fiscal year, but the same calendar year, i.e. November, am I correct in believing that the bonuses you said were reviewed for the test year all occurred, both earned and paid out within the test year?
No, so,
I'm sorry, I meant to include through the true-up period.
okay, then yes.
Okay. Did any of those AIP bonus payouts occur outside of the test year with true-up period? And I'm meaning either they were earned before the test year and then paid out during, including the true-up period, or they were earned during the test year and true-up, but not paid out until after. In any of those variations?
No.
Okay. And does the 12-month average customers used as the denominator in this metric include all rate classes or just residential? I asked this earlier of Mr. Weitzel.
From my review, I believe it includes all customers, but I would rely on Mr. Weitzel to verify that when he gets back to you on that.
Okay, that's all the questions I had. That takes us to recross. We start with the company.
So you were just asked about, whether the 12-month average customer denominator is all customer classes or just residential. Do you recall that?
I do.
Mr. Weitzel confirmed that that is all customers.
How about I offer a solution to
Yeah.
what I perceive as the issue? How about after Mr. Juliet, we will briefly call up Mr. Weitzel for this question and then open that question to cross.
I do not need to perform cross if Mr. Weitzel is just confirming that it applies to.
I want to make sure and get it on the record.
Fair enough.
Okay.
That would make it easier.
Yeah, I appreciate that, but I don't know if that would get it on the record such that we could all cite to it. But I appreciate your offer. We're still in the middle of recross. Thank you. Go ahead and continue, and we plan to call Mr. Weitzel for just a question after this.
Great, thank you. Mr. Juliet, isn't it true that there are non-monetary benefits to customers associated with Spire's incentive compensation plan?
Yes.
Can you elaborate on that? What, in your opinion, what are those benefits?
So, customer safety, response lead times, those, that specifically does not, provide a monetary value, but it helps ensure that the customer is safe.
Thank you. Nothing further.
Thank you, and we'll have recross from Mr. Kleiser.
Regarding that question you were just asked about other benefits, if the plan is put into place but not included in rates, will the customer still see benefits from the plan?
Can you say that one more time, sorry?
If the company continues the plan, but it's not paid for in rates, but it's still continued, will customers still see those benefits?
Yes.
Did staff make an adjustment to the true-up for the benefits from the 2021 AIP?
No.
So for the recross.
Thank you, and redirect.
Thank you, Judge. Are there benefits from the incentive plans that are in the test year?
Yes.
Mr. Clauser asked, if the incentive plans were not included in cost of service, would there be a mismatch of costs and benefits?
Can you ask that again?
If the incentive plans were not included in cost of service, would there be a mismatch of costs and benefits?
No.
So then would it be fair to say that the customers are receiving the benefits but not paying the cost?
Yes, that is true.
And that wouldn't be fair, would it?
No, that is correct. That would not be fair.
Hey, counsel. I am unable to hear you, but we are transmitting live on the internet. You may want to mute your mic as you talk to your advisor.
Mr. Kleiser asked about new benefits. Could staff reasonably separate test year benefits with new benefits going forward?
Yes.
Is it guaranteed that earnings will increase and achievements in the incentive plans, from achievements in incentive plans?
No, it's not guaranteed.
Would some non-monetary benefits have some monetary benefits?
Yes.
Could you explain, like maybe an example?
Of a non-monetary benefit, providing a monetary benefit?
Yes.
So the average lead time expense that I talked about earlier, though it's mostly non-monetary, if they respond faster to the leak, then they would be able to turn the customer back on faster, which would then increase the revenues over a longer response time.
Thank you, Judge. Nothing further.
Thank you. Mr. Juliet, I appreciate your testimony. You are excused from the witness stand. Mr. Weitzel, I would appreciate your presence once more on the witness stand. We have a single question to clear up. And I remind you, you've already been sworn in. That is still applicable. Please take a seat. Spire's witness.
Thank you, Judge. Mr. Weitzel, do you recall a series of questions that the judge asked you based upon page 23 of your direct testimony?
Yes.
And specifically, the denominator, the 12-month average customer in the utility adjusted O&M per customer formula, is that right?
Correct.
And the question, I believe, was, is that 12-month average for all customers or just residential customers?
I recall that question, and that is all customers.
Thank you. Nothing further.
We'll go to cross. Staff.
No questions. Thank you.
Thank you. Mr. Kleiser.
No questions.
Any commissioner questions? Hearing none. Any bench questions? I have none. Thank you, Mr. Weitzel. You're excused. We'll see you tomorrow. Mr. Schallenberg, please return to our witness stands. And you also have already been sworn. No need to repeat. I'll just remind you that that still applies. Go ahead and have a seat. Mr. Kleiser, your witness.
Attend to the witness across.
Ms. McKernan.
across at this time.
Company?
Thank you, Judge. Good afternoon, Mr. Schallenberg.
Good afternoon.
It's OPC's position that there should be no inclusion in Spire's cost of service of any incentive compensation expense. Is that correct?
Yes.
And does that mean that OPC opposes AIP expense for all employees, including union employees?
Yes.
Is it your opinion that Spire's incentive compensation program offers no customer benefits?
I'm not sure.
So for example, would there be a customer benefit to reducing the average leak response time?
Yes.
Could there be a customer benefit for having an increased customer satisfaction score?
Yes.
Could there be a customer benefit of having service call quality score increases
Yes.
or call center response time being reduced?
Yes.
Thank you. Nothing further.
Thank you. That leads us to commissioner questions. And again, we do have all of our commissioners either listening on the live stream or on the WebEx. If you are on a phone, it is *6 to unmute. Are there any commissioner questions for witness Schallenberg? I don't hear any. The judge does have a few questions. Mr. Schallenberg, your testimony's, I think, one of its main points was with this incentive program, the company would be saving money, and that savings is reward enough. They should not be earning a return on the investment.
In answering, I define reward, recovery of the cost.
Okay, thank you for understanding my nomenclature. In your recollection, has the commission ever directed a company to undergo an incentive program without there being a recovery? Has the commission ever taken the stance that OPC is suggesting and said, no, your benefit is the money you're saving?
Yes, if they've never said that you have to do an incentive plan, that you're not going to recover your costs ordered. Now, that they allow the companies to design their plans, and they may choose to design a plan that does that, but the commission has never required a certain plan be put in place that they aren't going to be allowed to recover, either through the savings the plan generates or through some differential going into rates or in a regulatory asset for recovery.
Can you give me any examples of where a company has come up with a program, as we're talking, where the company says, this is our program, we just need approval, but the money will pay for itself, and that goes forward?
Well, I don't remember a pre-approved incentive plan, but there have been incentive plans put in place
Can you put me to those?
that have been reviewed after. I remember Southwestern Bell had several plans. There were what they call incentive plans, was global
much they could keep it. And then as they earn more, there was a sharing plan that would 50% of the earnings in this range would go to customers as refunds, and then staggered until there was a point in time when all the benefits would go to customers. They're all acronyms, I don't remember them now. They were all acronyms that the commission would order. But in those cases, the company had to accept it. It wasn't, you're gonna do it no matter what. They would put it in as an alternative to a rate decision, and the company would say, yeah, we'll take it, or no, we won't.
Okay, thank you. That was all the questions I have. But that does cause us to have recross. We'll start with Ms. McKernan.
Staff just has one question. Were the incentive plans from Southwestern Bell a part of employee compensation?
I don't recall whether the plan, and there was one with the Union Electric as well. I don't remember if the company put in place employee incentive plans to support the global incentive plans.
Nothing further.
Thank you. And from Spire?
Oh, nothing further, thank you.
And redirect.
Good afternoon, Mr. Schellenberg. Okay, let's start with the question from the judge about whether or not the commission has ever approved for plans that don't seek recovery. To your knowledge, does a utility need to seek approval for an incentive plan if they're not asking recovery?
Normally, it would be no, unless it's a waiver of some rule. It involves a waiver of some rule that the incentive plan is operational and needs to achieve to be able to be implemented.
So utilities could already have these kind of plans in place. They just wouldn't have come to the commission for approval.
Yes, there's more that are done. It's just a company initiated plan.
So you were asked a question about whether the commission has ever directed companies to undergo costs without recovery. Are there other situations that are similar to the incentive plan situation where the commission has said positive regulatory lag is going to cover your costs, you don't need it in rates?
I remember cases where employee termination plans and the severance packages, they did make that decision. I don't remember the application of that same principle to an employee incentive plan. But there could be, I can't say I know all the cases.
But the commission has, for severance, for example, adopted the exact logic you're implying here.
Certainly.
And to your knowledge, is that not also the same position staff has taken with regard to severance?
Yes, except we've got a broader objection than just the one for the severance plan.
But the same logic still applies.
It does.
I think you were asked by the judge kind of the understanding of your issue. Is it correct? Well, can you briefly explain, just to make sure it's clear, what your opposition is to the recovery incentive plan?
Well, the first one would be, it's because the cost implementation is put in the rates before the related, and without related benefits. So that in essence causes a double recovery, something that the net to the company is going to be its cost less its benefit. So by just doing it piecemeal, you cause an overcollection, you get twice. there's another one, is these incentive plans usually have what I call a trigger, that the whole plan, whether you get payments or not, is based on a, earnings target or income target for the enterprise. And that part, if it's not met, none of the features, will be paid. It shuts down the plan. And because of the variation that occurs from year to year, the percentages of the payout will vary, and there's no, provision to pick up whether the amount drops or increases, excuse me. So, that's the known and measurable piece, because if you don't hit the earnings target, the whole plan is shut down. Depending on the variability of what the achievement level is, the amount of the payout will vary. And, the last piece is because, the fact that it's a year-to-year deal, it could be terminated at any year.
You were asked a series of cross questions by the company about customer benefits, you know, whether or not customers would see a benefit from these plans. Would you agree, well, if the plans increase revenue or decrease expenses, the company is always going to see a benefit, regardless of whether or not the customers benefit, right?
Yes,
And in fact, it's your position that the company's benefit will be greater than the cost of the plan itself, right?
it should be by design.
So these plans will be paid for by the implementation of the plan itself.
Yes,
So is it fair to ask customers to foot the bill for something that the company has already gotten paid for?
I would say, yes, I would define it being fair would mean there's no double recovery.
So it's fair if there's no double recovery.
Right.
And you would consider it is double recovery if you include the plans in rates, correct?
Yes, or if you include the plans and rates less the related benefits.
And you were asked a question by the company regarding incentive comp and whether or not you would involve unions. The OPC's position is not to disallow the incentive plans, correct?
Yes,
We are only asking for disallowance of the cost recovery, correct?
yes,
So the company can still put the plan in place, it can still benefit the unions, correct?
but yes, in the sense that it will make its union payments that it's committed to by contract.
And the company will receive the benefits of these plans and have every reason to put them in place regardless of whether or not their costs are included in rates, right?
That's assuming they design, a prudent, performance plan.
Thank you. No further redirect.
Thank you, Mr. Kleiser. Thank you, Mr. Schellenberg. Mr. Schellenberg, you are excused from our witness stand. I'd like to give a 5-minute warning for everyone. It appears that our hearing today will be concluded in the next 5 minutes. Just to give everyone the heads up. Does anyone looking at council in the room, does any council have on their schedule another witness under this issue for today? Okay. My question is on witness Meyer of Vicinity and MIEC. Yes?
Yes, they did withdraw their witness in a later filing of this updated witness schedule.
Thank you. Problem solved. Let's talk about announcements for tomorrow. 9 a.m. tomorrow is when we begin. Tomorrow's issues, and I'm just going to look for any no's. Residential rate design, that's issue 51. NOL carry forward, issue 16. And gross receipts tax, issue 18. Tomorrow is going to be the exciting day. That said, I'm drawing a blank. Is there any other announcements we need to make? We are adjourned for the day and off the record. I'll see you all tomorrow at 9 a.m.
Judge, I left this till off the record just because I didn't think it was necessary. With regards to Riley's updated schedule, you would like me to email those to Judge and all staff council, all council?
Yeah.
Okay, I will send those out.
Yeah, I'm only taking care of the court reporter record part.
This is the updated schedule you talked about, the ones that had an error, we were
Yes.
fixing it?
Yes. And I said, please give me the whole sheet so that the commissioners can see the whole thing at once instead of picking through the numbers. And we also talked about PDFs.